Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. Not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends, and thank you so much for coming to hang out with me this morning. Today is Thursday, April 3rd, 2025, and it's day 3 of jury selection on the Karen Reed case. How is everyone? I don't know. You guys say that it's skipping? Not skipping on my end. Maybe, I don't know, is YouTube having a problem? Refresh your browser, everyone. Everyone, refresh your browser. I'm watching it on my phone and it's not skipping. Maybe YouTube's having an issue? Go out and come back, everyone. Could be a YouTube problem. Laura says it's skipping like our heartbeats every time Bev speaks. I have the live feed up. I figured we'd watch court this morning and see if anything happens. That's more interesting than what happened yesterday or the day before, which is basically the judge giving everybody a welcome, a warm welcome. And remember, like I said the other day, you never get a second chance to make a first impression. So we're going to see what the jurors for today think of this first impression. Okay, I don't know. I guess the intro was, I don't know. Not enough coffee. Not enough coffee. And then we have some more filings to talk about and more decisions to talk about. And I'm sure that while we're here, that some more things will drop while we're here, because don't they always, almost every single day. We have the defendant's opposition to the Garret Wing motion to look at. And it's so interesting because it's exactly what I thought the other day that their opposition should be. Because remember, Hank Brennan said in his motion to exclude Garret Wing, the canine expert who's been training canine dogs and pets since he was a child for decades. Brennan's argument to not allow him to testify was that the defense is not entitled to a surrebuttal under the law. And there's no cases that, but apparently there are cases that say that you can have a surrebuttal. And he states, or Brennan says, he's only going to call Crosby on his rebuttal. So they should not be entitled to a surrebuttal, although he's wrong on the law, as usual. So it's interesting. Let me see, the live feed on News 10 is up, so we'll put it up. Hopefully it'll go as planned, and hopefully the sound will be better than it was yesterday in the courtroom next door for the Turk trial, because it was terrible. And I think it may have something to do with the weather. It may have something to do with the fact that there is so much media there covering the Karen Reed jury selection, even though there's really nothing to report about. So much. Oh, thanks, Cal. they're sucking up all the signal. And I think those of you who know there know that it's kind of a bad signal around that courthouse anyway, right? Because when we watch Tom CPU outside of court, he always has issues. And everyone who streams outside of the courthouse, Aidan, Will, the Glara, they've always got signal issues outside that courthouse anyway. And then when you have all of those media trucks there sucking up the signal, it's a problem. Oh, Toby Mama, I'm the sunshine in your day. Thank you. I was watching the Ozzy put a video out. I don't know if it was this morning or if it was yesterday. I think it was this morning because I watched it this morning, and it was, I love when she does the reaction videos, like the LawTube reaction videos, because it makes me feel less gaslit when all of the attorneys that are covering this case feel the same way. And it was our reactions to who knows, the latest thing that made us very angry. I think it was about whether or not she was going to let the ARCA witnesses be questioned about who they were hired by. And I was interspersed with, your other favorites, Emily Baker, Andrea Burkhart, Peter Tragos, Robin Runkle, and some others. And every clip, I was so angry. I'm like, I have to stop being so angry. I have to stop being so angry. But it's hard. It's hard not to be angry when you're invested in this case. It really is. I take things personally, even when they're not even my own case. It's the problem with being an empath is you feel things. You feel things. And so somebody says that the signal is really, really... Suze is there. Internet around the courthouse is horrific. I need to buy a Starlink for my car. I don't know, Suze. Sometimes I think they're jamming the signal on purpose because they don't want anybody to hear about it. Yesterday, we were watching the Turk trial in front of a great judge out of Norfolk Superior. His name is Mark Halal. This is a case that had originally been assigned to Judge Cannone. And when her cases were reassigned and she was specially assigned to continue with the Karen Reed re-persecution, she was taken off the Dr. Turk case and taken off the Brian Walsh case. And Judge Halal is sitting on the Turk case. It's about a doctor who murdered his wife. It's a horrible story. Fanning testified yesterday in the Turk trial. Turk is represented by Kevin Reddington, who represented Jen McCabe during the Rule 17 motions in the Karen Reed case. And yesterday, Fanning took the stand. It was interesting because, you guys, I went back and watched it. That's why we were so surprised when he came into the courtroom, because the ADA on that case, her name is Lisa Beatty. She said, okay, can you call next witness? She said Evan Walsh, and they were supposed to get Evan Walsh, the realtor, out of the hallway. But instead, Fanning comes marching in, and all of a sudden he's up there being sworn in. I don't know if that was like they were trying to distract us, like didn't want anybody to know that it was really Fanning that was coming in to testify. So he gets on the stand, and all of a sudden, the audio feed was terrible all day, but the video feed was great. All of a sudden, he gets up on the stand, and it was like the woman behind the curtain. All of a sudden, jammed the signal, and it was really blurry. Right? It was like Colleen Crawford was behind the curtain for her buddy Fanning and making it blurry. Do you remember that? That was crazy. Madeline says, I almost died when I saw Fanning. And yes, Reddington is still McCabe's lawyer and is friendly with Brian Albert, I heard. That I don't know. I didn't know if he still represented her or not. He's a good dude, says allegedly LB. That's what everyone says who has met him personally. He has said some very kind things about me on worldwide television. When he tried to get his change of venue out of Norfolk County, he said it was because there's a lot of publicity on this case. Meanwhile, there's not, because I'm the only one covering it with Broken Baker, as far as I know. We have double the amount of people in our live streams for this trial than Law and Crime does. So that kind of tells you something. But he said during his arguments in court that there's this one YouTuber. She's a lawyer from New York. Her name is Melanie Little. She's credible. She's not salacious. And then there's some other people out there that are covering this that are not so credible and are salacious. And so we think we deserve a change of venue. And Judge Halal's like, yeah, no, sorry. So he's been very nice to me, and he's a great lawyer. I mean, he's doing the best he can with what he has. Dr. Turk confessed to the murder. It's just a matter of whether it's going to be a first-degree murder with life in prison or if he can get it down to a lesser included manslaughter charge, which still is, 20 to 25 years. And rest in peace, Katie McLean. It's a tragic story. It's horrible. It was during the panning. It was in May of 2020, and he's just going to trial now. I'm not quite sure what took so long. If he waived his right to speedy trial, which is what I'm thinking. Good morning, Nancy Joe. Thanks for your super chat. I'm very concerned about jury selection. I do not trust this court, and I absolutely do not trust the Commonwealth. The feeling of dread I have in the pit of my stomach is overwhelming. Nancy Joe, join the club. You're not alone. Everyone feels that way because everyone who is on the side of Karen Read did not hit John O'Keefe with her car because John O'Keefe was not hit by a car, is very, very angry, confused, doesn't understand why this is happening. This is not the way our justice system is supposed to work. This is supposed to be about a fair trial for a defendant who's facing life in prison. This is not supposed to be a fair trial for the Commonwealth, which is what Hank Brennan is gaslighting everyone into believing. And if they really wanted the truth about what happened to John O'Keefe, first of all, they would have done a proper investigation, which is insane to me and you and all of us that are watching this. And second of all, they would just let all of her experts in, because don't we want the jury to hear possibilities of what may have happened to John that don't include a motor vehicle accident? Because I will tell you from my decades of experience handling thousands of motor vehicle accident cases, the injuries to John O'Keefe's body were not caused by a pedestrian versus motor vehicle accident. They just weren't. There are no injuries below the neck to the body of Officer John O'Keefe, aside from what looks like an animal attack to his right arm. There are no bumper marks. There are no injuries to his hips, thighs, legs, knees, nothing. And that's what happens in a motor vehicle pedestrian accident. You will always have bruising below the waist. It's just virtually, and think about it, it's virtually impossible not to. John O'Keefe's elbow was hit by that taillight at 24 miles an hour. His arm would have been shattered. It doesn't take a medical doctor to tell you that. Although during the first trial, Judge Kim Jong Cannone ruled that nobody but a medical doctor could testify with regard to any injuries to the decedent. However, she did let Yuri Buchanan, who's not a doctor, talk about what he thought caused the injuries. This time, she's decided that, yes, I've apparently changed my mind, although she won't say that she changed her mind and overruled herself, and she is allowing James Crosby, the Commonwealth expert, who is a dog behaviorist, to come in and testify about what he thinks are not dog bites to John O'Keefe's right arm. And so therefore, the defense hired Garret Wing, who is an amazing guy. I had on my channel over a year ago in January of 2024, when I was taken to task by Jennifer Koffendorfer on Court TV on Vinnie Politan's show, who tried to tell me that I was an idiot for thinking that his injuries to his arm were not caused by a car, because I'm not a medical doctor, and everyone who thinks they're a medical doctor comes in here and thinks they know what these injuries are. And so I didn't hire. The defense hired Garret Wing. I asked him to be on my show. He's got a YouTube channel. It's called American Standard Canine. He's got over 2 million subs. A lot of you had watched him before. He also does regular dog training videos, but he has a lot of videos of canine attack dogs attacking this prosthetic arm that he has to train dogs how to bite. And also bringing down perps, because they use the canine squad to bring in criminals a lot of the time. He did a great show with me. It was about, I don't know, an hour and a half to 2 hours long. It's on my channel. You can find it in the pre-trial playlist for Karen Read. Maybe I'll link it below if anybody hasn't seen it. And after the judge agreed to allow Crosby to testify, which we all know is mind-numbing, the defense hired Garret Wing. This guy's teaches dogs how to bite. He's seen more dog bites than anyone. And they're trying to keep him out. If the Commonwealth wanted to get to the truth of the matter and wanted to allow Karen Read to have a fair trial, which is her constitutional right under the Constitution of the United States of America, which is still where we live, they would just let everything in and let the jury decide. But they don't want that. They don't want that because they want a conviction. They want a conviction. That's what they want. All right. So far, as of close of business yesterday. And so, Nancy Jo, I'm here to tell you, just calm down. It's going to be fine. She's got an amazing team. They're some of the best trial lawyers in the country. You know it. I know it. We all know it. And it's all about picking the jury, right? It's all about the jury. So far, they have 7 total jurors. So they got 5 jurors yesterday, 3 jurors on April Fool's Day, which ironically, but really not so much, was the first day of jury selection. And they're looking for, I think, 12 to sit on the jury and then 4 alternates because as things go on with a very long trial, sometimes jurors have to drop out because of family commitments, family emergencies. Sometimes they are asked to leave the jury, as 2 of the jurors were during the first trial of Karen Read, one of whom, Victoria George, is now an attorney. Well, she was an attorney then, too. She was also pregnant with twins during the first trial. She was not so happy when she was picked as an alternate and wasn't allowed to deliberate. But her name is Victoria George, and she is now on the defense team for Karen Read in a move that was very surprising to a lot of people. She was so outraged by it that I think she was interviewed for, was it Vanity Fair? 7. They have 7 so far. Not 8, 7. She was interviewed, I think, in Vanity Fair, and she said that she was just basically horrified about our justice system and that, she couldn't believe it. And so she's walking in front of the pack as they walked into the courthouse yesterday. And so, there was another juror who was kicked off the jury without a hearing based on some hearsay that apparently came from Trooper Fanning to one of the court officers in the courtroom, who then related on to Judge Cannone. It was like triple level hearsay, where allegedly there may or may not have been a video of this juror, not Victoria George, a different juror, female, at the American Legion Hall talking about the case. And then when the defense brought that up in their motion to dismiss by saying Fanning was in charge of the jury, Fanning, came in with this information, Fanning, the judge got out in open court and said, oh no, Fanning is an upstanding, what did he say? You guys can tell me. Fanning is an upstanding, amazing trooper. He was in charge of all of the security for the courthouse because it was a very, very difficult job. And it was a very big deal because of all of the, I don't think she said anything about all of the supporters outside, but that's what she meant. She vouched for Fanning and said he never even came in the building. He didn't have any contact with the jury, shut it down without a hearing. And that was insane. So many things that have happened, very more so recently within the past couple of weeks, have been really, really out there type rulings. What we thought was very interesting yesterday in the Turk trial, when Fanning was questioned about his current duties, because he got a promotion, of course. So many of these law enforcement officers, despite their piss poor investigation for the murder of Officer John O'Keefe, have been promoted. I think almost every single one of them. When Fanning was asked what his duties are, he didn't mention anything about court security. In fact, he's the head of sex crimes or complaints for SA victims, which is also wild to me, being that he quickly ruled out Matthew Farwell as a suspect in the murder of Sandra Birchmore, closed that case quickly, ruled it a suicide. And now it took the feds to step in and indict Matthew Farwell on federal murder charges for the murder of Sandra Birchmore. I'm sorry. I'm thinking of Randy Churchwell and Sandra Birchmore. Sandra Birchmore. It's a very, very sad story. There's nothing funny about it, but he's now in charge of sex crimes. Really? That's great. Fantastic. Considering Sandra Birchmore was pregnant with married Stoughton police officer Matthew Farwell's baby. And he took her virginity when she was 15. And he met her when she was about 11 or 12 because she was a member of the Police Explorers program. No, you just can't make it up. You just can't make it up, can you? Good morning, Melissa. Thanks for being with me for 7 months. Appreciate you. On top, thank you for being on top of the super sticker. And again, says, all good. It worked. It worked by coming back. If it was skipping for you, just go out and come back in. Here we go. Hopefully the audio is decent today, but I can't promise anything. 11 months. Proctor's dishonorable discharge has been with me for 11 months. Oh, and a million hours of Attorney Melanie Little's YouTube. Thank you. I love you with all of my heart. Okay, there's Karen. She's speaking to what I think is an intern. They have, I think, something like 9 law school interns working for them for free. Some from Boston College, some from Harvard, and I think 1 or 2 from Northeastern. What an amazing experience for a law student to get to work on a trial of this magnitude. That will be a historical trial. And already has been a historical trial. Thank you, Crystal J. Oh, you got a stay classy, stay cool sweatshirt. Haven't taken it off. So many compliments. Love it. Free Kearney. We love you, Melanie. Love you right back. There's 20% off in the merch shop today. 20% off. This shirt that I have on says Free Karen Reed on the front. Oh, if you can see here. And then on the back, it's got the Stay Cool, Stay Kind, Stay Classy logo. And then there are some that say Free Karen Reed on the front that have the, I went to Cancun with Attorney Melanie Little on the back. Thank you, Crystal. I love you right back. There's POK's bathroom selfie. Well done. Became a member. Oh, welcome. Please do not send me that picture. I can't unsee it. Melissa Pert is here. If only Bev followed the rules, she explains to the jury. Also, the amount of law enforcement at Dedham Court is insane. They also they have a paddy wagon for you. They're getting ready to put you guys in the paddy wagon. And it's nothing like that paddy wagon in Chitty Chitty Bang Bang. Remember that guy who went, that creepy guy? What was his name? Children, oh children, do you want some candy? And he threw them in the back of that paddy wagon type. Might as well look like that. It's wild. Thank you for your super chat. LJ, good morning. Your thoughts on the Canton police audit report? Can the defense use this? So much evidence of policy breaches. Yes, I think we'll take a look at that. We're going to be here for a while today. This probably won't be that long. We're only going to see the judge address the jurors. What? Hey, guys, why don't you zoom in on Karen's phone so we can see who she's texting and what she's texting, really? They've already been admonished about this once or twice, and this is exactly what's going to get the cameras taken out of the courtroom. And nobody wants that. Oh, and now he figured it out, so he moved his camera. Well done to you, sir, or ma'am. Well done. I will put that on our docket for today. The Canton police audit, which is wild. They did find a lot of deficiencies in the investigation of the death of John O'Keefe. However, much of it seems to have been written by Chief Helena Rafferty, the chief of Canton PD. And they did say at one point in that report that it was an innovative use of a leaf blower. It was innovative of them to actually use a leaf blower. I don't know who they hired to do this. It's supposed to be some outside agency. But yeah, thanks, LJ. I'll put that on the docket for today. Thank you for your super chat. On top says, injustice is personal. It is, right? And I mean, I guess that's why I became a lawyer in the first place, because I wanted people who had no voice to have a voice. And I've always been a loudmouth anyway. So for me to get out there and start screaming for people who have no voice is just something I always wanted to do. And I guess that's why I take it to it so personally. When I sued the Catholic Church on behalf of, I don't know, I had at least 50 or 60 victims/survivors of clergy SA on Long Island when the original scandal broke in Boston all the way back in 2002. There was a movie made about it called Spotlight. Many of you know what I'm talking about. That case, it was a 16-year battle, sucked the soul out of me. All of the things that we uncovered about the Catholic Church and the policies that were in place to protect the abusers and how they were shuffled around from parish to parish, and how when a parent would come in with a concern about her child being abused by Father Fingers, there was actually a priest called Father Fingers, by the way, you can't make that up. They had a written policy in place, what to do, how to keep the parents from going to the police. Tell them we'll take care of it. We'll take care of it. God wouldn't want you to go to the police. Let us handle it for you. And they would shuffle that priest around to a different parish without ever telling the next parish to keep Father Fingers away from the boys because he liked the boys. It's really soul-sucking. It really is. And in the end, those cases were dismissed by the highest court in New York because of statute of limitations. Because if you could keep a kid quiet long enough, you would never go to jail. And you would never be able to be sued civilly. It's crazy. Eventually, after many, many years of lobbying, the Child Victims Act was passed, and it did open up a 1-year window for many SA survivors to be able to sue. And that's why you're seeing now a lot of these old cases being filed, because then there was an Adult Survivors Act also. So many new cases being filed for very old causes of action, like some of this stuff against P. Diddy. And that's why a lot of these cases are being brought in federal court in New York because of that 1-year window, which was eventually extended because of COVID. Thank you, K-Wags. I know you don't do X, but Mistrial Misfit has been asking Grok about Karen Reed key players. It's the hilarity we all need while we witness this debacle. Okay, great. So if you guys are on Twitter, I know most of my audience, I don't think is. Mistrial Misfit. Fantastic. I'll write that down. Okay, is that Victoria George that is talking to Karen right now? Let's see if we see her face. I thought her hair was darker, but I don't know. Thank you, K-Wags, for your super chat. M. Magil, thanks for your 10. Are your live streams eligible for CLE credits? Massachusetts doesn't require CLE, but I could use some credits for New Hampshire. I don't know. I don't know what I would have to do to get accredited for you. I'm happy to help. I mean, how many hours do you need of CLE, right? 24, 28, something like that. I'm sure that you have watched far more hours of the trial on my channel. Something I'm also trying to do is to teach. I have a lot of law students that watch me. And the only way to become a good trial lawyer is to watch really good trial lawyers. And so you can learn so much from watching trials as if you want to be a trial lawyer, because they don't teach that to you in law school. They don't teach you how to be a trial lawyer. They teach you about the law, but they don't really give you the skills that you need. The only way that you can learn them is by doing and by watching and by having a really good mentor that you can second chair or just go sit in the courthouse and watch trials. Because all the way back in the day when I was in law school, there was no court TV. I don't think court TV started until around the OJ trial. So like maybe late 90s. There was no live streaming of trials. I went to the courthouse and I would find some good cases that were going on and sit in the courthouse and watch. And that was always my idea of fun. Aside from Grateful Dead shows. It would be Grateful Dead shows or sitting in court watching trials. Crazy, right? Thanks for your super chat. Bloviating Greenan is here. He's really David Reese, and he changes his screen name often to go along with whatever's happening for that day. Almost a year, 10 months. It's a long-term relationship we're in, David. Thank you for being there with me. Stephanie Park is here. I'm a nurse practitioner at a large Phoenix hospital. I showed about 50 RNs and doctors at work the photo of Officer John O'Keefe's arm a few days ago. Everyone opined the injuries were due to an animal attack. Love the show, Mel. Oh, I love you, Stephanie, too. Right back. Right back at you, girl. Thanks for your super chat. Thanks, Dirty Deeds Done, not cheap. Oh, that's right. He was cheap originally with $75K at $250 an hour, but now he's a little more expensive, and it's going to be costing about $250,000 for the taxpayers of Norfolk County. I'm concerned about Hank's lying and gaslighting in front of the jury. Is there anything that can be done if he starts? Yes, they can object. And you can bet that they will. They will be objecting, the defense team, quite a bit. Although they won't be able to state the grounds for their objections, which is interesting because in the trial next door to this one, in the Turk trial, which is off today, by the way, that's why we're not covering it. They're off today and tomorrow. We go back to court on Monday on Turk from 10 to 2. They're allowed to state grounds for their objections. And they don't have to go to sidebar for every little thing. And it is one of the reasons I'm covering that trial is because of justice for Katie McLean and so many of her friends, and her daughter has been watching the show, and she comes into the chat and it's heartbreaking. Not only justice for Katie McLean, but also just to see what a difference a judge makes. Literally in the courtroom right next door to this one. We'll see what the volume does. I may need to modulate my own volume. God save the Commonwealth. Look at the ceilings in this courtroom. Beautiful. I think this is the courtroom that they tried Sacco and Vanzetti in. All the way back in like the 1920s. Thank you, Melanie's popped off head bucket. Oh, good name. Says, Melanie, you're the best. Hope you don't need me today. Oh, I love it. Melanie's popped off every day. I'm like, my head's going to pop off again. It's going to pop off again. There's going to be blood everywhere. It's going to be like a Monty Python skit. I love that name. Thank you for being with me for 4 months. I don't know what your prior name was, but that's amazing. We are also going to look today at Aidan Kearney's motion to be allowed to sit in the courtroom. So to be not sequestered. Look how beautiful that ceiling is. I mean, you can kind of see the molding there. Not so much, but it is a gorgeous courtroom. When Mark Betterow and I were in court, we took a peek in there because it's so beautiful and historic. We may have to jump around. Shannon says, stream is great on my end. Love you, Melanie. Truly the highlight of my day. Oh my gosh, you guys are killing me, really? I'm like, I have to stop being so angry. Ozzy had me angry that whole video. Every clip, I was more angry than text. It was a day. That was a day. Look, somebody said, the captions just said, I love you. And I'm pretty sure that's not what the hot mic said. I'm pretty sure. Melanie Schuyler became a member. Welcome. We have a lot of Melanies in this chat. I think I've already seen 3 or 4 today. I guess in this, back in the day when we were born, us Gen Xers, Melanie was very popular. Nessa, can Garret bring the fake arm into court? Great question. I think perhaps he will be able to use a demonstrative, but this court does not like demonstratives as much as Judge Halal next door loves the chalks. You should see some of these chalks that Kevin Reddington has. They're enormous. Some of them are double-sided. And the attorneys get along really well. Reddington gets along with the ADA, Lisa Beatty, really well. They kind of laugh when they're objecting. She's like, objection. Because Kevin Reddington is a little over the top. He's fun to watch, and he's funny. So typically, would an expert witness be allowed to bring in a demonstrative? Yes. She's allowing Judson Welcher to have a 140-slide PowerPoint presentation. That testimony is going to take about a week alone. Will she allow it? The answer is, I don't know. But will he bring it with him? I'm sure he will. He brought it on my show. Wasn't that awesome? Period, full stop. Can you explain docket number 661, list of jurors motion, okay? I think I did that the other day, but maybe not. I will put that right on the docket list for the day. Thank you for your suggestion. Thank you, Carmel McPartland, for your super sticker. Al dente. Defense expert, Holly Price. Is she a Google expert? Don't know, but I can Google her. Oh, do you want me to Google her? Or do you want to Google her? Or are you saying, is she a Google expert? I don't know the answer to any of those questions, but I'll put Holly Price on my list. Thank you, Al dente, for tuning in from Canada. The captions are so funny. It says, I got some packets for sports. Kansas sofa juror is here. Lady Justice is to be blind. Why does it seem there are so many judges who are pro-prosecution with their thumb on the scale? By the way, cute hat today. Oh, thank you very much. I was at Dead & Company at the Sphere last weekend with Andrea Burkhardt and her husband, Jeff, and we had a really wonderful time. So great to meet her. Her vibe is she's got such good vibes, you know? Vibes are on with her. You know, and it's funny because you watch someone on YouTube and you think you really know them, and like, she's what she seems to be. But so cool, so warm in person, really awesome. Why? I don't know. I have Lady Justice. Lady Justice right here. Here she is. She's got a blindfold on. She got the scales with her. My father gave me this when I graduated from law school. My parents did. And the answer is, I don't know. I mean, aside from Judge Gull, who, by the way, Kim Jong Cannone is in pretty serious competition with Judge Gull at this point. As I say, it's like, hey, Judge Gull, hold my White Claw. Check this out. There are a lot of fair judges out there. Even in this building, there are a lot of fair judges. We've seen them. Judge Halal, Judge Doolin, Judge Sisitsky, who was not having any of Brennan's BS. He wasn't having it. So I think if you have only been watching this trial, you have a very horrified sense of justice, and rightly so, because the bias is showing more and more every day. Thank you for your super chat. I dedicate Runkle's tweet to you, Melanie. I didn't see it, but I'll look for it. Thank you. Alessi never sleeps. You know, Ian and I have been in talks to do a show together. And we just got to get it together. And hopefully soon, because this jury could be picked. I mean, they've already got 7. They're looking for 16. Maybe they got another 4 today. That's 11. I mean, it could be picked. I think it's definitely going to be picked before the end of next week, which I would imagine she would want to start the trial on a Monday because, you know, got to go to the Cape early on Friday maybe to set up the summer house. And so my guess would be we are looking at a start date of potentially Monday the 14th. And that's my guess. I don't know that she would start it end of next week, but she may want to get it going just for convenience of the jurors. Thank you for being with me for 7 months, Marissa. GP Dog Drill, 11 months. Me too, time flies. Thanks for all you do. Thank you for all that you do and for all of you for being here, because you have a lot of choices where to watch your coverage. People who aren't as angry as I am. And so I think I speak for all of us with my anger. And you understand that when I yell, I'm not yelling at you. I'm yelling for you, really, and with you. And a lot of you say you always say the things that I'm exactly thinking. And it's wild to think that we collectively together have been covering this case on this channel since January 2024. 15 months. So for the entire 11 months that you've been here, GP Dog Jewel, we've been talking about this case and others. We've had a lot of trials in between. Thanks, Jay-Z, who's thanking me. No, thank you. And 11 months. I think I only started memberships like a little over a year ago. So thank you. So you're an OG. Susie became a new member. Welcome, Susie Bronco. Did I read that right? The judge is getting sued? Oh, yes, the judge is getting sued. We have that lawsuit as well. She's a named defendant in a federal lawsuit by some of the people who say their civil rights are being violated with her buffer zone. I don't know that anything's going to go anywhere with that, but we'll see. So we're going to go over that lawsuit too. Put that right on the docket. Thank you very much. Oh, and I was first notified about that, by the way. I have a viewer. I won't dox her, but she is a female sportscaster, and she's like 24 years old. And she's like, please excuse, I'm sending this from my work email. And then it had her name on it and her station that she works at. And so I had to Google her, and I'm like, oh my God, you're a female sportscaster. That is so amazing at 24 years old. Like, she's at in a smaller market, but she's really good. I predict that she's going to become famous. You heard it here first. She's tall. Maybe she played basketball in college. I'm not sure. But so many of the female sportscasters that we see on the field with these enormous football players are kind of on the petite side. And so I love that there's a tall woman getting out there and doing this. I love it. I'm so happy for her. Reed's bite is bigger than Chloe's. Member for 7 months. Ordering my Stay Classy, Stay Cool sweatshirt. Don't forget, you got it. You got to click here. Look, I'm going to just put this on for a second because they're not doing anything. Click this little, see where it says only 5 days left, 20% off of everything. Make sure you redeem that coupon at the top there. Ding, 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 ding. And then this shirt is the one I have on. It says, but I have the navy one on. It says free Karen Reed on the front. Stay cool, stay kind, stay classy. We are outraged. Attorney Melanie Little in the back. And then, of course, we have our, that also comes in a hoodie. And then, of course, maybe I'll put the link in the chat if you guys are interested. I really don't make any money off this merch. I just do it because you guys like it. There's this design that says free Karen Reed on the front. And in the back, it's got the I went to Cancun with attorney Melanie Little, established 2024. So that's kind of a fun thing if you need to get out there and, you want to support. I'll put the link in the chat for you guys. Also, the link to the Karen Reed Defense Fund is below in the show notes. And so if you have any desire to donate, these experts are very expensive, and we know they've got 12 of them. So far, I think one has been excluded. This whole thing is insane, and every day that goes by is just it's like another day in Norfolk County. I will say, oops. I don't even know if this is the right link. Tell me if it works. It's a very long link, so I'm not sure what I did here. I might have just put it to the special page where that shirt was. Okay. The oversized hoodies run much bigger, and also the zip-up hoodie is huge. It's huge, so size down on that. Some of the women's sizing is a little bit smaller, so just make sure you look at the size chart. And that's amazing. Thank you so much. Annabelle 14 became a new member. Welcome, welcome. Sammy Spills the Tea is here. Good morning from Plymouth County, Massachusetts. I think Bev needs to fill out this questionnaire. Yes, I think so too. Maybe then. Do you think she'd be honest about her bias, though? I don't know. Holly Johnson. Thank you, Sammy, for your super chat. Good morning, Holly. I was thinking scary, right? What harm does it create to have the FBI expert go over normal crime scene protocols and the reasons behind preserving evidence? Right. It causes harm to the Commonwealth because that expert is going to point out what a crappy investigation they did for not just a citizen of the county, but a fellow brother in blue. And that is why I think so many people are so angry about this. In addition to many law enforcement officers across the country. Like, really? This is how you investigate the murder of a brother in blue? Because many of them have responded throughout the course of their careers to motor vehicle accidents. And they know that this was not a motor vehicle accident. Because if it was, MSP would have filled out a crash report, a motor vehicle crash report, because it's required under the law. Not just if it's a fatality, but even if it's just an accident causing over a certain dollar amount of property damage or injury. And it was never done. Why? Ask yourselves, why was that never done? The damage that it would do is to expose these people for what, we all know. And so the judge is not going to allow Michael Easter to testify about that. But I need to go back on my own and look that over again, because I think that there were some other things that he was going to testify to, because he's also a cellular forensics expert. And so is he not going to be able to testify at all, or is he not going to be able to testify just about the improper police procedures, or what the proper police procedure, accident investigation, or scene investigation and evidence collection is supposed to look like, and how wrong they did it? Thanks, Holly, for your super chat. Mom to all four is here. You've got 4, I've got 5. Amateur. Just kidding. Thanks for a TikTok from Boozy Beauty. Appears the 24 miles per hour was the tow truck driver back in the vehicle and the tire spinning. Also a 3-point turn. Yep. Yes. I haven't seen her. I love her work. Haven't seen that one. But we've been talking about that for a year. Over a year. Well, I guess since the trial. Since they tried to say that key cycle was something else. And so I'm glad she did another video of it to explain it to people who haven't been screaming about that. Thank you for your super chat. Laura, thank you, Laura. Thanks, Laura, for your 10. Suze, the kids who destroyed that house walked away free. They paid the homeowners and made them sign an NDA. No charges to be out. What? What? Where can I find? Can you? I know you have my email. Can you email me like the article or how some source to that? So for those of you who don't know, something that happened a couple months ago, there were a bunch of kids in Canton who went and had a house party at a girl's house from the high school. Who the house was under construction. They went in there and videotaped themselves smashing walls, destroying the house. They did at least $100,000 worth of damage to that house. They killed a bunny, I think. They were seen kicking around a dead body. Oh, it's in the police audit. Thank you. Thank you. And it was speculated or rumored that some of those kids, did it say that there was a Lank, an Albert, and a McCabe involved? I don't know if that's true. Did it say that? And they only had to pay $20,000? I didn't read all 200. I think it's 206 pages, but that's insane and disgusting. And yeah, like, if you had any doubt, and I said this the other day, I forget which decision we were reading. Oh, it was the third-party culprit decision about how Colin Albert is not to be mentioned. And the judge's order states things that are contested facts as facts. All the evidence says that Colin Albert was not in the house when John and Karen got, like, these are contested facts. And I said, if you ever had any doubt that Michael Morrissey's office is not there to protect the Alberts and the McCabes, you should have absolutely zero doubt about it now after that decision, because that's insane. Especially after those emails came out in which, it's in the Betterow letters, it seems that Julie Albert was emailing with the PR mouthpiece guy for the DA's office at the time, David Traub. He has since run away and works for a private firm. And David Traub says to Julie Blank and some other person, maybe Chris Albert at gmail.com, who at the time and still is, was a town of Canton selectman, which is like their town board. David Traub says to Julie Blank, Chief Rafferty has relayed to me your concerns, and we are actually filming the statement that you suggested right now. And remember in that hostage statement that Morrissey did, that video in August of 2023, he mentions Colin Albert more than anybody else, at least 4 or 5 times. Colin Albert was never in the house. The harassment of these witnesses has to stop. He's an upstanding young man. I mean, it's being used in law schools right now to teach law students what district attorneys should never do. And it's getting to be so in your face right now that it's like they're not even trying to hide it. I can't wait to look at that with you, the audit report and that portion thereof of those kids trashing that house. Just South History, hello. Wish you were on Twitter. Nominations for free Karen Read hotties floating. Or what? Definitely need a nomination for me. Oh, you're so sweet. I haven't seen it, but you can email me the link to it if you want. Thank you so much. Here we go. God save the Commonwealth. Thanks for your super chat, Justice South of History. Just South of History. I was reading that as Justice. And thank you, Be Our Best Just, for thanking me and being with me for 9 months. That's amazing. Thank you. Deborah Claire, I'm grabbing 2 voodoo dolls and lots of pins on vacation to New Orleans. Gonna name them Hank and Beverly. Appreciate all you do for us. And look at you, Deborah. You spelled Beverly correctly, unlike Juliana Nagel, who in her Venmo payment to Ryan Nagel, in which she wrote for Frank and Beverly. That's kind of funny because Beverly's husband's name is Frank, but Julie Nagel spelled it Beverley. And during the motion to recuse, the defense team had a giant chalk of this Venmo transaction. And the judge said from the bench, I have never rented out my Cape House to anyone, and that's not the way I spell my name. If you know, you know. Thank you so much, Deborah, for your super chat. Thanks, Karen. Thank you, Karen, for your super sticker. All rise. God save the Commonwealth. Jim. Jim. Let me know in the comments if you're watching on replay what your first impression of the judge and the attorneys would be if you were.
All persons have made business before the Honorable Cannone, Justice of the Norfolk Superior Court, and before the County of Norfolk. You are here, if you're attended, you shall be heard. God save the Commonwealth of Massachusetts. The court is now open. You may be seated.
God save the Commonwealth.
I'm sorry, could you stand and raise your right hand one more time? I need you to stand and raise your right hand, jurors. I'm sorry. My fault. Do you solemnly
My fault. My fault. My fault. He needs to swear in the panel. That's what he's doing now.
swear to make true answers to such questions as we put forth to you by the court, so help you God? Thank you. You can have a seat now, I promise. May I call the case, Your Honor?
Please.
Your Honor, this is docket number 2282CR117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
May I introduce myself, Your Honor?
Please.
Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts, along with two of my colleagues.
Good morning, my name is Laura Laughlin. I'm the Assistant District Attorney for the Norfolk District Attorney's Office, representing communities within Norfolk.
Good morning, my name is Adam Lally, Assistant District Attorney with the Norfolk County District Attorney's Office. Thank you very much for your time and attention.
All right. Thank you.
Well, Mr. Brennan is looking at Twitter. You know how I know? Because this is the first day of 3 that he's allowed Adam Lally to introduce himself. Somebody, I think, posted that on Twitter, and he actually allowed him to introduce himself today. He's watching. Look at the upper right corner of your screen. It's like a salesman badge. Hello, my name is Hank Brennan, because that's what he sounds like.
Thank you, counsel, and then counsel for the defense, and please introduce your client as well.
Good morning. Let's try that again. Good morning. My name is Alan Jackson. I have the privilege and honor to represent my client standing to my right, Ms. Karen Reed.
Good morning, ladies and gentlemen of the jury. My name is Elizabeth Little, and I also have the privilege of representing Ms. Reed.
Good morning. My name is Robert Alessi. I likewise have the privilege of representing Ms. Reed, and I thank you for coming today.
Good morning, my name is David Unetti. I'm an attorney. I have offices in Boston and right here in Dedham. And it is truly my pleasure to represent Karen Reed.
Good morning. My name is Victoria George, and I have the privilege of representing Ms. Reed, and thank you for being here.
Good morning, I'm Karen Reed. Thank you for being here.
Okay. Thank you very much.
Did you notice how the judge said, because I was going to say, Karen has introduced herself to the jury for the past 2 days, and the judge just said, and you can introduce your client, as if she didn't want Karen to introduce herself to the jury. Did you pick up on that? Because I did. Wow.
Ms. Reed, can you please remain standing for just a moment? Karen Reed, you are now set at the bar to be tried, and these good men and women who I shall call to pass between the Commonwealth and you upon your trial. If you'd object to any of them, you must do so before they are sworn. You have a right to challenge any 16 jurors without giving reason. Thank you.
That means they get 16 peremptory
Good morning,
challenges.
jurors. My name's Beverly Cannone. I'm a judge of this court, and I want to welcome you here today and give you some idea on how we think your day is going to shape up. So I just want to say before we start that Jury service is certainly one of the most important civic duties we have, and as a civic duty, it does cause us to be inconvenienced. So we do appreciate that you're here, ready, willing, and able to serve if called upon to do so, and our system of justice simply won't work without you. So we do appreciate you being here, and we appreciate your patience. So today we're selecting a jury in the criminal case of Commonwealth versus Karen Reed. The Commonwealth alleges that at approximately 6 a.m. On the morning of January 29, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours.
Here's what I don't like about what she just said. The police arrived to find 3 women with John O'Keefe. No, Jennifer McCabe was not with John O'Keefe. Jennifer McCabe was still sitting in her car, or she was near her car. She was not with John O'Keefe. She should have said, the officers found 3 women at the scene, right? The 3 women were not with John O'Keefe. She's making me mad already.
Of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was later pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations. She is presumed to be innocent, and she has pled not guilty to the indictments. So the defendant is charged with second-degree murder. She is also charged with manslaughter while operating a motor vehicle under the influence of alcohol and with leaving the scene after causing personal injury or death. I'll describe these offenses in greater detail at the end of the case when I teach the jury the law. But briefly, murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted to proceed under all theories it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder.
The Commonwealth is allowed to proceed under all theories. Take that back. That they believe could be true. You know who's not allowed to do that? The defendant, Karen Reed. She's not allowed to say that Colin Albert might have done this because the judge said so. Ipsy dixit. Why are we giving more rights to the Commonwealth than the defendant? That's not the way our Constitution is supposed to work. And our founding fathers are rolling over in their graves right now. Listen to her say that again.
Murder case, and the Commonwealth is permitted to proceed under all theories it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder and that that murder was murder in the second degree. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, the issue of public interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence in the courtroom at all. The law works in a different way, and the difference is crucial to our system of justice. The jurors selected for this trial will hear and judge the evidence. They will decide what the facts are, and where the evidence is contested, they will determine where the truth lies. Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this criminal trial will be decided by an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important.
Really? It's
So while
that simple.
public
If it's
comment-
that simple and that important, why are you throwing wrenches into her entire defense? Somebody in the chat asked, is Alessi Jewish? First of all, why does that matter? What a weird random question. Alessi's an Italian name, so I mean, why would you even ask that?
That will likely continue, the rule of law will be upheld. In order to determine your eligibility to serve on this case, I'm going to ask questions to you all as a group, and then I'm going to ask you to fill out a supplemental questionnaire. We have found that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, in the process of filling out the questionnaire, you're provided the opportunity to be more reflective as you answer the questions, rather than being put on the spot and asked to give immediate answers. After you fill out the questionnaires, we'll have you come up to the sidebar one at a time so that we can follow up on your answers to the questionnaire and to questions I will have of you. I want to thank you in advance for your patience as we go through this process. As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you may be excused during the impanelment procedure. If you're not selected for jury service on this case, please don't take it personally. Don't think that somehow you're not a fair person. It's not a reflection on you at all. You will be directed back to the jury room and perhaps picked on a case, different case from another court. In a few minutes, I'll pose a number of questions to you as a group, and you've just taken an oath that requires you to truthfully answer these questions and all questions put to you. If your answer is yes to any question, I will ask you to raise your hand and hold up your juror card in the air with the numbers facing out so that the court officer may read the numbers from the card. You don't have to get the numbers out now because it will still be a few minutes and I'll let you know.
She's already chastising
The fact
them.
that you answer yes to one of my questions does not mean that you're automatically disqualified from serving on this jury.
Yeah, let the sirens go by.
We hear ambulances and fire engines going by every day, many times during the day. And if you're selected as a juror in this trial, we'll be seated in the courtroom across the hallway where we'll hear it even more. So generally, the lawyers stop and I stop talking when we hear it. So if you find a...
I don't know, am I too biased or is she just not very personable at all? Like, she couldn't seem less interested in this case. She couldn't seem less interested in being here today. She couldn't seem less interested in giving this spiel to the jury. She has zero fire, zero riz, zero gravitas. It's disappointing at best, but maybe I'm just too biased.
question that I pose to the group is overly intrusive, you can elect to answer that question at sidebar. And I'll probably have additional questions for you which relate to issues that may be raised in the trial and are designed to give us information regarding your ability to serve as a fair and impartial juror, and the lawyers are permitted to ask you questions for the same reason. This is not a test. There is no right or wrong answer.
This is not a
All we're
test.
looking for is your best, honest answer to the questions. Now, I have a witness list that I'm...
But if I hear from somebody who hears from somebody who heard from another person who heard from somebody before that you may have been out at the American Legion Hall talking about the fact that you were on this jury, I'm just going to kick you out without even asking you whether it's true or not. And if you don't know, well, then you're off the jury. So, guide your actions accordingly, everyone. Somebody wants to know how many they're picking. They're going to pick 16 total, 12 main jurors, 4 alternates. They've already picked 7, so they're going a lot more quickly than I thought they would.
I'm going to read to you, and it is very lengthy. It doesn't mean that all of these witnesses will be called as jurors, but you will likely hear about these witnesses. So I'd ask that you listen carefully, because in a few minutes I'm going to ask you if you know any of these witnesses.
Again,
It's alpha.
can they not get a list? The other jury questionnaires that we've looked at, for example, Ashley Benefield, weren't they given a list of witnesses and said, check off the box if you know them or you think you might know them? And if this is the first time that you're listening to the witness list, or I'm calling it the witless list, this is the combined witless list. It's alphabetized by first name. But if you are Dr. Marie Russell, you're in the D section, even though none of the other doctors are in the D section. If you're Trooper Michael Proctor, you're in the T section, even if you are a now disgraced former Trooper Michael Proctor. And if you are something like, maybe if you're a sergeant, you're in the S section. Don't ask me, but everyone who has OCD is freaking out about it. Okay, here we go.
Alphabetical.
Yeah,
but it's
alphabetical.
of these witnesses.
Listen.
It's alphabetical, but it's alphabetical according to first name.
First name or title, because you know what? I think they didn't want all the Alberts in a row. Maybe they didn't want all the O'Keefes in a row, because then it has their town of where they live next to it. And it seems that Peggy O'Keefe and John's father do not live together anymore. And Aaron and Paul O'Keefe do not live together anymore. And that is not an invitation to talk about other people's marital problems. I'm just pointing it out that perhaps that is the reason. And Aidan is number 1 on the call sheet. Yes, he is. Aidan Kearney. Notice how she doesn't say Aidan Kearney, AKA Turtleboy, because a lot of people that know Turtleboy may not know Aidan Kearney's real name. I don't know. This is a new batch of jurors today. So that's why they got to go through this spiel every day. I'm pretty sure it's new. Maybe some are left over from yesterday. Not quite sure. Here we go. She's pissed because she's getting sued, says Melisa. Yeah, but she was pissed the other day too. Like, she never has any fire in her belly. She seems annoyed that she even has to be there. Right. Why isn't Garret Wing in the L section? He's a lieutenant. I mean, just listen, because now that I've told you, it's going to freak you out a little bit.
So, Aidan Kearney from Jefferson, Massachusetts. Dr. Isaac Wolf from South Miami, Florida. Alfred Lopalato from Canton. Allison McCabe from Canton. Andre Porto from the Massachusetts State Police Crime Lab. Andrew Klain from Bridgewater. Andrew Rentschler, PhD from Pittsburgh, Pennsylvania.
Crash Daddy.
Excuse me. Angela Malvone from Canton, Mass. Annie Chung from Canton. Anthony Flamati from the Canton Fire Department. Ashley Bell from Canton. Ashley Villier from the Massachusetts State Police Crime Lab. Brian Albert, Norwood. Brian Albert Jr., Boston. Brian Higgins, Sandwich. Brian Loughran, Canton. Brian Wanless, who is retired from the Canton Police Department. Bridget Meehan, who is a keeper of the record for Canton.
She's the owner of the Waterfall
Caitlin
Bar.
Albert.
Something else that I just noticed, which I'm very happy about, is that young Brian Jr., Bri, has moved out of his parents' house. Praise be. Got away from those people. Bri, we're here for you. Do the right thing, man. Do the right thing.
Easton, Mass. for Canton. Caitlin Albert, Easton, Mass. Lieutenant Charles Ray of the Canton Police Department. Police Chief Helena Rafferty of Canton. Chris Van E., who's a PhD from Novi, Michigan. Christine.
There's a name she knows how to pronounce correctly. Helena Rafferty. I've been calling her Helena, but I guess it's Helena because that would be one that she would know how to pronounce, right?
Tina Hanley from Massachusetts State Police. Christopher Albert, Canton. Christopher Curran, Canton. Colleen Crawford from the Norfolk County District Attorney's Office. Colin Albert, Canton. Courtney Proctor, Canton. Kurt Roberts, Canton. Daniel Whitley from the Canton Fire Department. Daniel Wolf, PhD, from Penns Park, Pennsylvania. Derek Ellington from Wake Forest, North Carolina. Dr. Marie Russell from Los Angeles. Dr. Elizabeth LaPosada from Providence, Rhode Island. Elizabeth Proctor from Canton. Eric
Oh, they must be listening because they put Dr. Loposada in the D section also, but not Dr. Irene Scordi-Bello. So notice there were only 2 doctors listed under the D section, and there are several more doctors on the witness list.
Hanlon from Canton. Erin Beatty from Canton. Erin O'Keefe from West Bridgewater. Francis Walsh from the Canton Fire Department. Garret Wing from Green Cove Springs, Florida. Gary Fowler from Brockton. Gregory Woodbury from the Canton Fire Department. Gretchen Voss from Boston. Hannah Knowles from the State Police Crime Lab. Heather Maxon from Walpole. Herberto Hernandez from the Boston Police Department. Holly Price from Mountain View, California. Ian Whiffen from Vienna, Virginia. Dr. Irene Scordi-Bello, who is with the Office of the Chief Medical Examiner, Massachusetts.
Wait, then why is she not in the
James
D
Crosby,
section?
who's a PhD from Jacksonville.
Okay, you just screwed the whole thing up. Hold on. Did she say Dr. Irene Scordi-Bello? But she's not in the D's. Why is she in the I's?
Holly Price from Mountain View, California. Ian Whiffen from Vienna, Virginia. Dr. Irene Scordi-Bello, who is with the Office of the Chief Medical Examiner, Massachusetts. James Crosby, who's a PhD from Jacksonville, Florida. Jason Becker from the Canton Fire Department. Jean DeMoulis from Canton. Jennifer McCabe, also Canton. Jessica Hyde from Bridgeport, New York. John O'Keefe Sr. from Braintree. Judson Welcher, who is a PhD from a company called Aperture LLC. Julie Albert from Canton. Julie Nagel, also from Canton. Dr. Justin Rice from South Weymouth. There are 2 juveniles from Canton, one of whom's initials are KF and the other PF.
Wait, Farmer, does Colin live in the basement? Because that would explain the 3 flights of stairs that he alleges when he came home. He had to go up to kiss mommy and daddy goodnight, even though they weren't home. Had to come down. Oh, mommy might have been because she allegedly had a migraine. Come down and then get his water and then go into the basement. That's the 3 flights of stairs. Oh, I didn't know he lived in the basement. Thank you.
Caitlin Boudreau from Raynham. Karina Kolakathis from Canton. Katie Camarano from Canton. Katie McLaughlin from the Canton Fire Department. The keeper of the records for Ring from Hawthorne, California. Kerry Curran from Canton. Kerry Roberts, also Canton. Kevin Albert, also Canton. Kevin O'Hara from the Massachusetts State Police.
TB12, hashtag Foxborough, the jurors are in the room for this because this is jury selection. So they're still picking the jury. This is the panel. Somebody said there's only 40 in the room today. I'm not sure. We'll hear when they start raising their paddles about the questions, but they're still picking the jury.
Lance Mello from the State Police Crime Lab. Laura Sullivan from Pembroke. Laurie Cahill from Worcester. Leslie Pearlstein from Canton. Lieutenant Michael Lank from the Canton Police Department. Louis Jutras from Canton. Lieutenant Brian Tully from the Massachusetts State Police. Lieutenant John Fanning, also State Police.
Yeah, see, the lieutenants are all under the L's. That's why a lot of people thought they didn't hear Proctor on the list, but that's because he's under T for trooper.
Lieutenant Paul Gallagher from the Canton Police Department. Maggie Gaffney from Bonita Springs, Florida. Mark Lopolato from Canton. Margaret O'Keefe from Canton. Marietta Sullivan from Pembroke. Mary Souza from Dighton. Matthew Amory from Canton. Matthew DeSogra from Charlotte, North Carolina. Matthew Erickson from Grosse Pointe Farms, Michigan. Matthew Kelly from the Canton Fire Department. Matthew Kelsch from the FBI. Matthew McCabe from Canton. Maureen Harnett from the Mass State Police Crime Lab. Megan Mariani from New York, New York. Michael Camarano from Canton. Michael Easter from Los Angeles. Michael Trotter from Canton.
See, they still have Easter on the list, who's the FBI expert. So if she precluded him from all of his testimony, he wouldn't still be on the list, right? So I'm imagining maybe he's going to get to testify about the cell phone data, triangulation, and geofencing. I don't know. Got to look into that a little more. Because this is day 3, right? She would have picked it up by then, just like Hank Brennan picked up the fact that maybe he should let Big Boy Lally introduce himself to the jury instead of doing it for him.
Michael Wagner from Foxborough, Mike Maroli from Bridgewater, Mike Rushworth from Thompson Station, Tennessee,
Mike Rushworth, fun fact, is Bird on the text message thread with Michael Proctor. Remember Michael Proctor's nicknames were Chip and Bear, and there was a guy named Bird? That's him.
Natalie Wiewick Berschneider from San Marino, California.
Natalie the German.
Nathan Reed from Raynham. Nicholas Bradford from Lorton, Virginia. Nicholas Curran from West Roxbury. Nicholas Kolakethis from Canton. Nicole Albert from Norwood. Norfolk County District Attorney Michael Morrissey. Officer Kelly Deaver from the Boston Police Department.
Notice that Michael Morrissey is under N for Norfolk County. District Attorney Michael Morrissey. He's under N. Because you just can't make it up.
Department. Officer Nicholas Barros from the Dighton Police Department. Patrick Haggerty from Somerset. Paul Mikowski from Melrose. Paul O'Keefe from Canton. Rebecca Bison from Canton. Rebecca Trayers from Norfolk, Mass. Dr. Renee Stonebridge, also from the Office of the Chief Medical Examiner at Boston.
But she's not under the
Richard
D's.
Green from St. Pete Beach, Florida. Richard Donatino from Canton.
D'Antuono.
Robert Gilman from Hull. Ryan Nagel from Canton.
See, she said Richard, whatever she said, Donatino. His name's D'Antuono. So they'd be like, oh yeah, I know a guy named Ricky D'Antuono. I don't know a Richard D'Anton, whatever she just said. What'd she just say?
Richard Green from St. Pete Beach, Florida. Richard Donatino from Canton.
Donatino.
Robert
D'Antuono.
Gilman from Hull. Ryan Nagel from Canton. Sarah Levinson from Canton. Sergeant Brian Gallerini from the Needham Police Department. Sergeant Sean Good from the Canton Police Department. Sergeant Paul Giampetro, D. Giampetro, I'm sorry, from the Canton.
Wait, should we ask her to check off the boxes on all of the people that she has personal relationships with on this list? Or that she's rented her summer house to potentially, or, you know, people who she owes favors to? Because I'd like to know how many people she knows on that list.
Canton Police Department, Sergeant Yuri Buchanan from the
She
Massachusetts
can pronounce
State Police.
Buchanan.
Shannon Burgess from South Lake, Texas. Cheryl Waugh from Canton. Sophie Herzon from the Massachusetts State Police Crime Lab. Stephanie Devlin, also from the Crime Lab. Stephen Mullaney from the Canton Police Department. Steve Nelson from the Norfolk DA's office. Stephen Bernstein, who's a keeper of the records in Stoughton. Stephen Ridge from the Boston Police Department. Stephen Seraph from the Canton Police Department. Stephen Scanlon from West Roxbury.
Scanlon.
Terry Kuhn from Davis, California. Tess Chart from Lorton, Virginia. Thomas Beatty from Canton. Thomas Kelleher from Canton. Thomas Martin from Weymouth. Timothy Nuttall from the Canton Fire Department. Tristan Morris from Easton. The following are Massachusetts State Troopers. Tristan Morris is from Easton, Mass. Trooper Connor Keefe.
Tristan Morris is like the most know-nothing witness of the trial. He knows nothing. Do you know what time it is? Nope. 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 Do you know what you did? Nope. Nope. He's now married to Caitlin Albert.
Trooper David DeChico. Trooper Evan Brent. Trooper Jeffrey Kostkowski. Trooper Joseph Paul. Trooper Kathleen Prince. Trooper Michael Proctor. Trooper Nicholas Garino. Trooper Zachary Clark. Wendell Robery from Canton, Mass. And William Reed from North Dayton,
Never
Massachusetts.
call him Bill Reed. Never.
I appreciate your patience in listening to that list. There are a lot of people, so obviously this trial is going to take a while.
A lot of people? A lot of witnesses?
We've already begun our impanelment process. We will continue to impanel. We don't know how long that's going to take. As soon as we start the trials, the lawyers tell me that their best estimate is that the evidence in this case will take 6 to 8 weeks. That's an estimate. It's a good faith estimate. We do the best we can to let you know in advance how long we expect something to take. It may go a little longer, it may go a little shorter. If you're selected as a juror, I will let you know at the end of every day. It's my practice to let jurors know where we stand, if we're on schedule, if we're behind schedule, which I can tell you has not happened, or if we're ahead of schedule. So I let you know every day where we are. That's
Wait, which I can tell you has not happened, that we're behind schedule? She kind of just let them know that there's been a first trial, no? I thought they weren't supposed to know that there's been a first trial. Right. Behind schedule hasn't happened. Yep. Does that give them a little hint? Well, I mean, they do ask them whether they've heard about this case, so I guess most of them do know there was a first trial. But if we're trying to keep out the fact that there was a first trial, why is she right? This is the third day she has said it. I want to hear that again. I can tell you that's never happened. I mean, I don't know.
every day. It's my practice to let jurors know where we stand, if we're on schedule, if we're behind schedule, which I can tell you has not happened.
Has not happened.
Or if we're ahead of schedule. So I let you know every day where we are. That's the best we can do, and it's a good faith estimate. We just want to give you as much information as we can in advance, as much as we can.
We'll let you
We
know if we're
expect
calling a
that
half day for Taco
the case will
Tuesday,
go from
Margarita Wednesday, get to the Cape early Friday, or come in late from the Cape off on Monday. We'll try and let you know that ahead of time so you can actually have a life outside of this alleged 6 to 8 week trial, which I think is going to take longer. Because I think Brennan is a windbag, and I think he's going to be talking a lot. He's going to have a million objections. You think she meant not behind at the moment? Well, I think you're giving her too much credit, Jay. Not behind schedule at the moment? You're giving her a lot of credit. That's very nice of you. It's very, you're showing her some grace. Thirsty Thursday, right? My freeze game on point, as always.
9 o'clock to 1 o'clock every day. We'll take a break around 11 o'clock for 15 or 20 minutes or so. Lunch will be provided to you. We're trying to take advantage of your time here with us. So rather than break for an hour to go out for lunch, which usually turns into an hour and 15 minutes or longer by the time we get things set up, we want to keep you here for a lunch break. We'll provide lunch for you, and we'll continue to move the trial forward throughout the day. The afternoon will go from...
Aren't they required to buy them lunch? Why is she making it sound like it's like a punishment that they have to stay there for lunch because we don't trust you to get back here on time? She's so boring. And I think her throat chakra is blocked. I think she needs an unblocking of the throat chakra because, you know, that's what she was doing when I froze the screen before. They're entitled to lunch. That's the only thing they get out of this is a free lunch. Okay? That's why a lot of juries deliberate through lunch when they're deliberating and return a verdict after lunch because they want the damn free lunch because they don't get paid very much. And a lot of them don't get paid for work.
From 2 o'clock or so, or right after lunch, maybe 1:30, and you'll go until about 4 in the afternoon. There'll be some days here and there that we won't be in session. And there'll be a few more days that we'll do half days, just morning. So we'll let you know in advance those dates. And again, that's the best we can tell you now. So it might help you if I also give you a preview right now about some basic law that applies to criminal cases like this. As I've said, it's my job to teach the jury the law, and I don't...
No, Mass Dad. It is not her job to teach the jury the law. Are you with me on this, or is this just the way they do it in Massachusetts? At the end of the case, I will instruct you on the law. And even if you don't agree with the law, you have to agree that you will follow the law, and that is something they often question on in jury selection. They didn't ask a question, I don't think. We went over the questionnaire. They didn't say, even if you disagree with the law, do you have trouble following the law? Her job is to instruct them on the law, not to teach them the law. This is not law school. You're not a teacher, even though I think maybe you want to be a teacher.
Do that completely until the end of the trial. So for now, I'll give you a brief summary of some of the very important legal principles that will govern this trial. First, and most basically, Ms. Reed starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation.
It's toilet
An
paper.
indictment is merely a formal manner
case.
of accusing a person of a crime in order to bring that person to trial in the Superior Court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove his or her innocence or to produce any evidence whatsoever or to do anything other than attend the trial. This presumption of innocence remains with the defendant until the jury make your determination after you listen and consider all of the evidence. Another important principle of law is that the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the government, you accuse me, now you prove it, and prove it beyond a reasonable doubt and to a moral certainty. I do not have to say a word. A defendant's
Quick shout out to distractors, hyperbole, and flummoxification. I don't know what your name is, but your YouTube video that you posted, somebody sent it to me. I hadn't seen it. And it was a video, if I do say so myself, of my outrage at reading the third-party culprit decision about how the judge was talking, how the Colin Albert issue. And it is my outrage kind of narrating this video and then interspersed with clips of Colin Albert on the stand, clips of Ally McCabe on the stand, and clips of Colin Albert and some other things. And it was really, really good. So shout out to you. Maybe I'll link it, if it's okay with you, I'll link it under the video and you guys can watch it later. That was really well done, except for some of them. I mean, based on whatever equipment you had, I'm zoomed in and I'm blurry, but that's okay. I'll allow it because the points that you made in that video, based on the things that I was saying during my video, and then you proved them, you backed it up, you had the receipts for it. Chef's kiss. Love it. If you haven't watched it, I'll link it.
decision whether or not to testify has not.
This is who did it. I put their name up on the screen, on the screen. Distractors, hyperbole, and flummoxification. That is the YouTube channel.
Nothing to do with the question of whether she is guilty or not. The jury must not consider it in any way or even discuss it in their deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. Now that brings me to reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, but it is not easily defined.
No, it's not actually well understood at all because the jury in the first persecution, Kearney, didn't understand reasonable doubt. So please do not put the burden on them to now assume that they understand what it is. You know, maybe you actually should teach them about that because nobody seems to know in your courtroom what reasonable doubt is.
Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in the case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty. a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a
No distractors. It's not your equipment. It's just that because I'm so small on the screen, you had to enlarge me. I get it because I'm tiny over here in the corner. We know who Colin called at 12:33. He called Erin Beatty, and she's on the witness list. Aidan Kearney's done stories about it. But yeah, I want to hear that witness as well.
reasonable doubt.
To pick him up from 34 Fairview.
Now, our system of
Wait,
justice...
and just somebody's asked me if I can play that. I can't play the video because there's music attached to it and I'll get stricken for copyright for the music. However, when I watched that video last night, it made me remember that Colin testified that Allie McCabe picked him up at his buddy's house, I forget the buddy's name, and drove him to 34 Fairview. My guess is that the screenshot of those text messages, parts of which were doctored, which I think is the timestamps, he was telling her, hey, you can come get me now at that guy's house. I think the guy's name was Mike, to drive him to 34, not to pick him up. I don't know. That was my thought. You think she's shuttling him around all night because he doesn't remember what time he went there, but he knows he left at 12:10. She's got nothing better to do than to drive around her cousin or not even cousin. Mike something. I want that guy on the witness list. Get Mike on the witness list. The guy, and so that he can say what time Colin Albert left his house and whether or not Colin Albert bragged to him after January 29th about anything that may or may not have happened in the house.
Justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Now, of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful.
Wait,
First,
we judges have the same bias as everyone else. Not all the judges actually show it the way that you do. And if I wouldn't take her recommendations for strategies of controlling bias very seriously because, well, you know why. You're going to share some strategies with this panel of jurors who can tell how disinterested you are in being here today. Thank you, Midnight Mike, for gifting 5 memberships. And for those of you who were gifted, Midnight Mike is an amazing member of this channel and always so very generous. She's going to give them some helpful strategies to help them with their bias because she knows she's biased, but now the whole world knows it too. Listen to this.
and that's what I'm talking about. Now, of course, we judges have the same problem as everyone else, so let me share a few
It is a problem.
strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases.
No, because when you took weeks to decide that motion to dismiss in your 26 or however many page ruling, your biases were very, very clear. The fact that you slowed down to write it did not help you with your bias at all. In fact, it made your bias even more obvious, I would submit to you, Kim John Cannone. And you never rule from the bench. Is that why? Because you need to like go back and figure out your bias. The only time we've ever seen you rule for the bench is number one, when you shut Alessi up and told him to talk to the hand on the motion where the Commonwealth wanted to obtain the privileged text messages between Karen and David Yannetti. And you decided, no, you're not getting that, which we were all shocked by. And the other time I remember you ruling from the bench is when you decided not to recuse yourself before the first persecution. If anybody else can point me to a place where she actually ruled from the bench, please let me know. Yeah, slow down and let your bias stew so you can harness the true power of the force. Goblin Misfit, it's on my phone so I can't highlight it, but excellent comment.
Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no
unless you ask for evidence, in which case we won't give it to you. So, for example, when the first jury asked for the cert report because they wanted to know who found the first pieces of taillight and how many pieces of taillight they found during that dark search in like 18 inches or so of snow. I guess we'll know how much snow there actually was because the weatherman is going to be allowed to come in and testify. And I think even is he going to be able to testify about the hardness of the ground? I don't remember. But I know that Dr. Wolf, the brain surgeon, is going to be able to talk about the hardness of the ground because, you know, Cannone. But even when you ask for evidence, we're not going to let you have it. They asked for the cert report during the first jury deliberations, and they said, no. The judge said, no, you have everything that you need. Instead of telling them, no, you can't have that report because it doesn't exist. So we're going to lie to you. We're going to gaslight you. And, you know, good luck to y'all. Peace.
need to start making your mind up before then. Make a careful decision. You will have all the your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making your mind up before then.
All the time you need,
Third.
except for when, you know, you agree to acquit on 2 charges. Sorry, I can't help interrupting her because she's boring the shit out of me. But, oh, sorry. Sorry, kids, if you're in the room. Not my kids, your kids. We're going to give you all the time that you need, but we're going to give you really hazy instructions. And so even if you decide to acquit on some counts and not others, we're not going to even ask you about it. So that might really piss you off after you're done here. And like the last jury, they decided to acquit on first-degree murder and leaving the scene, which makes no sense to me, because if they were hung on count 2, which involved a hit and run, how can they acquit her of leaving the scene? It makes no sense, but whatever. We're going to give you all the time you need, except for when you say, you know, you have Grok or, you know, Claude or whatever AI program, ChatGPT, write your notes, and the foreman won't let you say what you want to say. It's a whole thing. But jurors, don't worry. You're going to get all the time you need and all the evidence you want, and it's going to be great.
You should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in the case, consider them as individuals rather than as members of a particular group. And finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will...
Or if they're in a group that involves my friends and family, or, you know, if one of their fathers is the town selectman, you know, would I view it? What if one of their fathers was not the town selectman? Would I view it differently? Wow, this is very, I didn't pick up on this day 1, so this is a whole new monologue for me for day 3, because we didn't do day 2.
Would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law without sympathy, bias, or prejudice to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of it's confusing at this early stage.
Or perhaps you've already fallen asleep or looked at your watch, because I'm really boring. And yes, all you need, Kenny Peterson, except for readbacks. So if you want to know what a certain witness's testimony was, even though there's 150 names that I just read to you and all 150 may be testifying, even if you're back there arguing about what a certain trooper said in the T section, or what a certain doctor said, or what a certain witness lied about, if you're back there because all of your notes are unclear and maybe you didn't take notes, and one guy thinks his notes say something and one lady thinks her notes say something else, and you ask for a readback of that testimony, we're not going to let you have it. See, where I come from, the land of New York, juries are given readbacks every single day. How can they possibly be expected to remember every little nuance of testimony, every little lie that was told, every little conflict in their testimony? How can they be expected to remember that when we are putting somebody's life in their hands? Karen Reed is facing life in prison if she's convicted of second-degree murder. And yet, if the jury wants you, is arguing about what a witness said, you're not going to let them hear the testimony read back to them? That is wild to me. I think it's a Massachusetts thing, or perhaps the judge has the discretion in Massachusetts to allow it. This judge does not allow it. And so they're relying on their notes for 6 or 8 weeks of 150 witnesses. Are we trying to get at the truth, or are we just trying to throw everything at the wall and hope that these 12 people come out with the right decision? It's insane to me. You can't put someone's life in a jury's hands and then not give them the tools that they need to come to an agreement. I don't like it, and it makes me madder the more I think about it.
The case. You'll certainly be in a better position to understand this at the end of the case when you have heard the evidence and I can explain the law in detail. So don't be worried if you didn't catch everything I've said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree with the law, but all jurors will have to apply the law as I describe it. So, for jury selection, it is important to know if any of you might have some doubts whether you can accept and follow these legal principles. So go ahead and take those cards out because I'm going to start asking you those questions.
Okay. I like to make hash marks for this so we can figure out how many.
Before we begin, I understand that sometimes jurors do not fill out the juror questionnaires completely. Sometimes we're in a rush to get those forms back in, or sometimes we think that maybe our experience doesn't apply to the question that's asked. So when you come up to sidebar, if we see that something's missing, sometimes people forget to put in a work experience. Many times people forget to put in their age, and we do ask about that. We need that for purposes of this impanelment. But sometimes people forget to put in whether they were a witness in a case that was in court, a defendant, another litigant. So if there's anything that's missing, we'll ask you, but if you know that you didn't put something on there, please let us know at sidebar.
Yeah, that's the one I said.
All right, so if your answer is yes to any question that I ask, please raise your hand until the court officer reads your number. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses whose names you heard?
Juror number 343, 360, 347, 339, this clerk will be scratched, 360.
Thank you.
Juror number 348, juror number 344, juror number 333, juror number 310, juror number 355, juror number 332, juror number 323, and juror number 312.
Okay, thank you. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with the lawyers in this case or the Norfolk County DA's office?
What about the defendant?
Juror number 326, juror number 328.
Thank you. Do any of you
Only
folks
two?
or a close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome? I see no affirmative responses. Please raise your hand if you have seen, heard, or talked about this case.
Juror number 319, juror number 317, 352, 353, 311, 343, 360, 347, 354, 324, 328, 322, 326, 339.
juror number 338, juror number 355, juror number 332, juror number 349, juror number 325, juror number 323, juror number 337, juror number 350, juror number 312, and juror number 359.
Lastly, juror 329.
All right, thank you very much. Could you please raise your hand if you have expressed or formed any opinion with respect to this case?
Juror number 319, 353, 311, 343, 347, 354, 322, 326, 339.
Juror number 330, juror number 333, juror number 344, juror number 348, juror number 361, juror number 341, juror number 310, juror number 334, juror number 320, juror number 312, juror number 350, and juror number 325.
Thank you. Are any of you aware of any bias or prejudice that you may have in regard to this case or in favor of or against either of the parties? Please raise your hand.
Juror number 326, 328, 354, 319.
Thank you. Do any of you folks have any difficulty hearing or any problem with understanding the English language or any physical or mental condition or any religious or philosophical beliefs that would interfere with your ability to hear the evidence in this case, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict? Could you please raise your hand if you do?
Juror number 344, juror number 321, juror number 325, and juror number 342.
Thank you.
Number 360, 324.
Thank you. Please raise your hand if you think you will have any difficulty following the important constitutional concepts that I've described to you. First, that the Commonwealth has the entire burden of proof in this case. Second, that that burden of proof is proof beyond a reasonable doubt and to a moral certainty. And third, that the defendant is presumed innocent and does not have to do a thing other than sit in that chair for the trial. Would anybody have any difficulty applying those very important constitutional principles? If so, please raise your hand. I see no affirmative responses. I can tell you folks that after every jury trial, I talk to jurors. And though they may not have been thrilled about having jury duty, they always tell me that they have found the experience to be a very interesting one, and often jurors tell me that they find it to be a very rewarding one.
Yeah, except for when you don't ask them if they've reached a verdict on any of the counts, because did you really go back and talk to the last jury? Because some of them wanted to tell you that. So it's not so rewarding when you acquit a person of murder and the judge doesn't ask you if you did, and then she is now going to be re-persecuted on the same charges. It's called double jeopardy. So those important constitutional principles that you were talking about, that's one of them. You have the right to not be tried twice for the same crime. And here we are. Well,
But I do understand that with this case and the schedule, it may be an undue hardship for some of you. Let me tell you what I mean by undue hardship. When I told you earlier that all civic duties cause us some inconvenience, an undue hardship or a substantial hardship is much more than that. It's something that means that it's personal to you, and the person sitting next to you will then have to step in and give up time from their lives. I generally think of it in terms of either you're a student or you have airline tickets or surgery scheduled for the time that we will be on trial. So with that in mind and that very rough definition, please raise your hand if you think that you have a substantial hardship that will prevent you from being a juror in this case.
Juror number 319, 317, 352, 311, 343, 360, 354, 326.
Juror number 361, juror number 348, juror number 351, juror number 346, juror number 333, juror number 355, juror number 338, juror number 334, juror number 310, juror number 341, juror number 350, juror number 323, and juror number 325.
Okay. So in a minute, I'm going to leave the bench and give you an opportunity to fill out those supplemental questionnaires. I ask that when you do so that you don't talk to anybody about your answers to the questions or to share any comments with other jurors or concerns that you may have about being a juror in general or a juror in this case. If you have any questions or concerns, you can talk to me when we come back out. So with that, we will be in recess. Jim?
Yes.
Court, all right, please.
Seems there's only 40 jurors there today. There's only 40 jurors there. All right, blah, blah, blah. Of the 40, 37 of them raised their hands or their paddles when they were asked if they had seen, heard, or talked about the case. 37 out of 40. With regard to whether they'd formed opinions about the case, 21 out of 40. Whether they thought they had a bias or they were already in favor of a particular party, 4 out of 40. It's 10%. Whether they had a substantial hardship like a vacation or surgery. But I guess only if the vacation includes plane tickets. Not really sure. 21 out of the 40. And according to Christina Rex, 93% today knew of or talked about the case. Yesterday was 89%, Tuesday was 86%, and the last trial was 75%. Those are the statistics. Thank you, Boiled Frog, who says we have to amplify this injustice. Hit the like button, gets the algorithm moving. Yes. Go to the chat before we start talking about some of the papers. Thank you, Karen, for your super sticker. Susie H, need help. I can't find the membership button. How to join? I've joined other channels, so I've done it before. If you have an iPhone, it's wonky. Sometimes you have to close out the chat, but in the video, the show notes below, I always have a link for membership. So you can just go to the show notes and there should be a link there. Hope you can find it. Thanks, Susie, for even wanting to join. Appreciate that. And Susie Bronco, thank you for tuning in for Canada with your super sticker. Thank you, John Fowler, for your super sticker. Posse says, Lori Vallow is defending herself. Tried putting a journalist on the witness list. Interesting to watch someone defend themselves if you have the time to cover it. I know that trial, I think, starts on Monday. And we need to finish the Turk trial because I've already committed to justice for Katie McLean. But I am interested in seeing that. I don't know, maybe I could do recaps or something and we could talk about the most important points of Lori Vallow because her representing herself, I think, is going to be a train wreck, but that should be something you can't turn away from. Thanks, Potsy. Tracy, did they decide on the alcohol admission? I haven't seen a decision on that yet. I have not seen that unless it's in my inbox, unless it came in today. Haven't seen it yet. Thank you, Tracy. Susie became a new member. Welcome. Good morning, Ipsy Dixits. Can we all call the CJC and complain about bias bev? I cannot, as an attorney, as a member of the bar, recommend that or encourage that. So I cannot even endorse that in any way, shape, or form. Thank you, though. Dobie Mama, thank you for being a member for 8 months. Loves watching it here with us and the cupcakes. Thank you. Jamie, this is all you do. I'm your hero, Jamie. Oh, that is so sweet. Thank you for your 5. Free Karen and Justice for John says, what an epic move for a former jury member to join Karen's team and face the judge from this angle. Trial of a lifetime. Yes. Oh, I rock. You rock. You rock. Thank you. I'm ordering merch now. Oh, thanks, Jenna. I hope you like it. Judy, will Brennan's lack of integrity affect his career? Listen, once he made that motion about trying to get privileged attorney-client text messages, what defendant is going to hire him when he's already shown the world that he doesn't think communications between an attorney and a client should be privileged? I mean, who's going to hire him? It'll remain to be seen. Does he have political aspirations? Does he want to run for office? I don't know. But I think a lot of defendants would be like, yeah, I'm not hiring that guy. He doesn't think anything I say to him should be privileged. He thinks it's cool if the other side wants our text messages. No. Thanks, Cast Me Out. Time flies when you're tried for murder twice. Thank you for hanging out for 11 months. I appreciate you. Boiled Frog, thanks for your super sticker. Bev's panic attack. If policy and procedure is common knowledge, then there's no need for the academy, right? Oh, well done. Well done. Oh, no, there is, because you have to learn how to fight in things like fight night or the big fight, in which case you might get killed. And then it takes, I don't know, it's been how many months since Enrique Delgado Garcia died at the academy, and there were tons of witnesses. Nobody knows anything about it. There's been no reports. It's been over 6 months, right? Thank you, Bev's panic attack. And Bev's bias beratements. Look at that. 2 in a row. 2 great names in a row. Can you explain how they choose the jury, please? As in, how do the attorneys agree who goes on or not? Oh, thank you so much for your compliment. So each of the jurors or the potential jurors are called up to sidebar one by one. It takes forever. They are questioned about things that they checked off on the juror questionnaire that we went over 2 days ago on the stream before this one. If all sides can agree that the juror should be stricken for cause, like they have a bias or they can't follow the law or they have a hardship, those jurors are asked, that juror is excused. And in this courthouse, they have to go into another room to be selected potentially on another case, I guess. And if there's a reason why one of the sides wants the person off, even though it's not for cause, just because of their own reasons, they each get 16 peremptory challenges. And if everyone agrees on a juror, as they're called up to sidebar and questioned mostly by the judge and a little bit by the attorneys too, then they are seated on the jury. And so far they have 7, and they're looking for 16 total. So hopefully that answers your questions. So they get to have 16 each without a reason, and then they can argue for cause. M. Mange, nothing to see here, says, when are these people going to pay for their crimes? Rhetorical question, right? Brooke, thanks. I was watching the Byrne murder trial yesterday, and out of nowhere, Karen Reed is guilty started flooding the chat. Definitely astroturfing. Oh, that's interesting. Where were you watching it on Law and Crime? Or Court TV? Janelle, 17 months. Wow, you are definitely an OG. I think you are one of the first members. You're not too mad, just passionate. Thanks for all you teach us. You are right up there with Ed Wallace teaching us the law. I love Ed Wallace. Thank you, Janelle. That's a compliment. Mary Effin Poppins. Mary Effin Poppins became a YouTube member. Welcome. Closed captioning said Aunt Lally. Oh, that's fantastic, Tracy. Thanks. LJ, Bev almost slipped and almost said she is to be proved instead of she is presumed. OMFG. Thank you, LJ. Have they chosen the jury? Is that why Bev is teaching them the law? I'm behind. No, this is the speech, the spiel that she gives every day when the new panel comes in. And we wanted to watch it again today because I saw it was live. So that is not why. No, she's just telling them ahead of time to see if anybody has any reason why they wouldn't be able to follow the law. YouTube turns thanks to the file with a lawsuit Friday against Beverly Cannone and the buffer zone be televised. I don't know. It's federal court. If so, will you be doing content on it? I'm going to read it to you today. I have it on my little list of things we're going to do today. So maybe we'll do that first, since many of you might not have seen it. But because it's federal court, it will not be televised. But we will take a look at it. Of course, we'll go over this, the lawsuit, the opposition, and I'm sure there will be a motion at some point or just a ruling from federal court. Emma is here from Ireland. Bev is the biggest obstacle to Karen getting a fair trial and Officer O'Keefe getting justice. Thank you, Fairy Raven. Sue's 40 new jurors in court today. 35 from yesterday will be called back. 7 seated. Just sent you 661, 662. I think I have those already, but I will see. Thank you, Suze. I'm a little behind in the super chats. My autistic son says she's Judge Dredd, says Minor Skill. Something, there's an emoji that I can't say, her law, that I can't see, her law. Thank you for your super chat. Is there any recourse for biases judges like Bev? Maybe on appeal, but an appeal would have to involve a conviction, and we don't want that. Thank you. Lorelei Annie. Keely Clark, Rustin Meyer, is that Lally's kennel next to Hank on the ground? Well done, sis. Well done. Thanks for your super chat. Joe Davis, a year ago today, I had a stroke. I'm so sorry. In the hospital, passing the time, came across your YouTube channel, and now you're watching every day. That was a year ago that you started watching. Oh, Joe Davis, I hope you're doing well from your stroke. That's amazing. And prayers up for Joe Davis. Thanks so much for your super chat. Holistic Therapist became a member. Welcome, welcome. Factually Innocent. Thanks for the 10. Jamie D, it must be just exhausting for Auntie Bev. I mean, all that pressure from Marcy and the Alberts. Thank you for your thoughts. LJ, they can't even get this list in correct order. How can anyone trust anything they say? Right. Right. Greg, wait, did I hear that right? Keeper of records for Ring apparently doesn't have a name. You just said the keeper of records for Ring camera. Well, that's the thing. So when you subpoena someone from a company to come in to authenticate records, usually you don't know who they're going to send. So I'll allow it. I will allow it, Greg, but I like your attention to detail. Thanks for the 5. Solid as a rock, Mr. Weatherman. Christina Rex says on Twitter, 4 jurors present, 35 from yesterday will be back at 10:30 for questioning. Oh, so they're going to do more? More questioning, but she's not going to have to give them the spiel again. All right, that's cool. Good to know. I mean, I'll keep the feed up in case they come back, but or in case, you know, there's anything interesting that happens that we need to pivot to, because we can do that. We've got the capability. Thank you so much, Mr. Weatherman. On top, literacy buildings on hooked on phonics with dyslexia on full display to please the court. Thank you. On top. Kyle says Trooper Proctor, he should be under F for former, yes, or D for disgraced. I would allow that too. Thank you so much. Midnight Mike gifting 5 memberships. Okay, well, Court TV cut their feed, so I guess they're not coming back. Thank you, Mike, again, for gifting 5 memberships. I appreciate you. Holly Johnson. Karen Reed is innocent until proven guilty. Why can't she introduce herself in court? Well, she did actually allow her to. Bev is so disrespectful toward Karen. I am disgusted. You're in good company, Holly Johnson. You're in good company. Alexa's room is here. Thanks for your 10. Says still howling at throat chakra. I mean, she did do this. Isn't that like a sign of a blocked chakra? And that's what I learned in yoga. Thank you so much. Colin Albert did it. Thinks the judge is horrible. Thank you for your 5. D says, I couldn't watch a trial anywhere else. Thank you for your hard work on our behalf. Love your perspective, and you're always saying what I'm thinking. You had me at Costner. That was my first stuff. My first content was Kevin Costner's divorce, right? Oh my gosh, how far we have come since then into the outrage and the shock and horror. All right, I think what I'd like to do, let's take a look at the lawsuit against Judge Cannone, since I think some of you may not have heard about that or even seen it yet. And now I just have to figure out where in my downloads I put it. Here it is. The plaintiffs in this lawsuit are Jason Grant, Allison Taggart, Lisa Peterson, and Samantha Lyons. I am not familiar with any of these folks. I don't know if you guys are. But let's take a look at this. First up, new lawsuit just filed. It's filed on April 1st, but I don't know when it hit the docket. I don't know when it was scanned or anybody knew about it. Let's take a look. This is a lawsuit in the United States District Court for the District of Massachusetts. And again, the plaintiffs are Jason Grant, Allison Taggart, Lisa Peterson, and Samantha Lyons. Plaintiffs versus Trial Court of the Commonwealth of Massachusetts, Beverly J. Cannone, in her official capacity as Justice of the Superior Court, Jeffrey Noble, as the superintendent of the Massachusetts State Police, Michael D'Entremont in his official capacity as chief of the police department of the town of Dedham, Massachusetts, and Michael Marcy in his official capacity as the Norfolk County District Attorney. Defendants. I need to just take a very quick break. I'm going to leave this on the screen for a second. Grab yourselves a drink or something if you need it. I just have to do something real quick, but I will be right back. Never fear. I'm always here. Oop. Okay, sorry about that. It's hard to get things done that you need to get done when you're on the air all day long. Okay, here we go. This is the verified complaint in federal court. The Karen retrial has drawn significant public attention. This is filed by Randazza Legal Group, who filed the last buffer zone motion before the first trial, which kind of went nowhere. So I don't know if this one's going to go anywhere, but we'll see. The Karen retrial has drawn significant public attention. Plaintiffs are members of the public who wish to publicly express themselves near but not on the grounds of the courthouse where the second Karen retrial is taking place. Their primary concern is that they wish to criticize Judge Cannone. So these people, and you're going to see there's some photographs attached, their criticism is toward the judge specifically. They have been doing so since November of 2024, so that was after the first trial, without incident. Love my red pen. They've been doing so peacefully. They've been doing so while Judge Cannone presides over cases in the Dedham courthouse, and neither the Sixth Amendment nor the First Amendment have felt the slightest chafe. However, Judge Cannone has found her pretext to shut down protests against her and ignoble requests from the Commonwealth that an ill-defined buffer zone be declared on the streets, public walkways, public library, and private properties surrounding the Dedham courthouse. Judge Cannone joyfully entered the order ex parte, and that's true, because nobody was heard on that motion, enjoining plaintiffs and everyone else who are not subject to her jurisdiction from speaking on private property and on traditional public fora, which is the plural of forum. We learned something already today. Somebody said, can we do a word of the day when Alessi is on? And yes, I'll allow it. It is a lawless, ultra vires act that violates the constitutional guarantees of free speech and due process. Cannone has issued this order primarily to quash criticism directed at her. As this, the only protests that have been documented have been the plaintiffs in this case, who have quietly held signs criticizing Cannone. To remedy this constitutional wrong, the plaintiffs Jason Grant, Allison Taggart, Lisa Peterson, and Samantha Lyons bring this civil action against defendants, Trial Court of the Commonwealth of Massachusetts, Beverly J. Cannone in her official capacity as Justice of the Supreme Court, Jeffrey Noble as Superintendent of MSP. Bet he's glad he took that job, huh? He's a Jersey guy who was brought in to be the new chief of police. Michael D'Entremont, in his official capacity of chief of the police department of the town of Dedham, Mass., and Michael W. Marcy, in his official capacity as the Norfolk County District Attorney. Plaintiffs bring a claim under 42 United States Code Section 1983 for defendants' violation of their First and 14th Amendment rights and allege as follows. This is a civil rights cause of action. That is why it is brought in federal court. And that is why they are able to sue the judge directly. The parties. One, plaintiff Jason Grant is the natural person who resides in the Commonwealth of Massachusetts, and that is the same for all plaintiffs. Allison Taggart, Samantha Lyons, Lisa Peterson, they all live in Massachusetts. Defendant Trial Court of the Commonwealth of Massachusetts is a judicial entity organized under Massachusetts General Law, Section 211B, 1. Number 6, defendant Beverly J. Cannone is a justice of the Norfolk County Superior Court and at all relevant times worked in Dedham, Massachusetts. Defendant Michael Marcy is the Norfolk County, Massachusetts District Attorney and at all relevant times worked in Norfolk County, Massachusetts. Defendant Michael D'Entremont is the chief of police department. I'm probably pronouncing that wrong, but I like a little French. You know, it's always good to have a little French in your day. Chief of the police department of the town of Dedham, Mass, and at all relevant times worked in Dedham, Mass. Defendant Jeffrey Noble is the superintendent of the Massachusetts State Police and at all relevant times worked in the Commonwealth of Massachusetts. Jurisdiction and venue. This court has subject matter jurisdiction over this civil action per 28 U.S.C. 1331, as this is a civil action arising under 42 U.S.C. 1983 and the First and 14th Amendments to the U.S. Constitution. This court has personal jurisdiction over all defendants as they are all citizens or organs of the Commonwealth of Massachusetts. Well, if they're organs of the Commonwealth of Massachusetts, we know Beverly Cannone is not the heart. And we know Michael Marcy is not the brain. You know, so there's that. And the defendants committed the acts complained of within the said Commonwealth. Venue is proper in this court pursuant to 28 U.S. Code 1391 B1 and 2, as all defendants reside in this district and all events giving rise to the claim occurred in this district. Factual background. On or about January 29th, 2022, John O'Keefe, a Boston police officer, died. On or about June 9th, 2022, a true bill was returned in the trial court of the Commonwealth of Massachusetts Superior Court Department, Norfolk County, indicting Karen Reed and charging her with a second-degree murder, with a second-degree murder of O'Keefe, B, killing O'Keefe with her motor vehicle while intoxicated, and C, a hit-and-run death of O'Keefe under General Law 90. Defendant Cannone is the presiding judge in the Reed prosecution in the case styled Commonwealth v. Reed in the trial court of the Commonwealth of Massachusetts Superior Court Department, Norfolk County, hereinafter Reed case. The Norfolk County District Attorney's Office, led by Michael W. Marcy, is prosecuting the Reed case on behalf of the Commonwealth. A trial in the Reed case was held in 2024, which resulted in a mistrial after the jury failed to reach a unanimous decision. Hereinafter, first trial. The second trial in the Reed case began on April 1st of 2025, hereinafter, second trial, and that was the same day this lawsuit was filed. Prior to the first trial, the Commonwealth filed a motion to inter alia, means among other things, Latin of the day, create a buffer zone beyond the grounds of the Norfolk Superior Courthouse to prohibit any individual from demonstrating in any manner about Reed, law enforcement, the DA, potential witnesses, and evidence within 500 feet of the court complex during the trial. Massachusetts citizens Tracy Ann Spicuzza, Lorena Jenkinson, Dana Stewart, Leonard, and Paul Cristoforo thereupon moved to intervene for the limited purpose of opposing the Commonwealth's buffer zone motion. The motion to intervene was denied by Justice Cannone, who declared that the citizens had no right to intervene, even though the order would directly affect them. Shocking. Judge Cannone then issued an order granting the Commonwealth's motion, asserting that the Commonwealth's perceived inconveniences overcame everyone else's First Amendment rights without regard for any differentiation between members of the public, and expressly ordered that no individual may demonstrate in any manner, including carrying signs or placards, within 200 feet of the courthouse complex during trial of this case, unless otherwise ordered by this court. That was the first buffer zone order. Right? Yes. This complex includes the Norfolk Superior Courthouse building and the parking area behind the Norfolk County Registry of Deeds building. Individuals are also prohibited from using audio enhancing devices while protesting, such as like the bullhorn. 23. Speech that does not qualify as demonstration was not restricted. But that says demonstrate on. I'm confused. Thus, a nearby cafe could advertise breakfast using a bullhorn and parade its menu on picket signs and placards. Celtics and Bruins fans could similarly honor their teams by hooting and hollering and carrying placards. And in fact, commercial speech was permitted within the zone. 24. In advance of the second trial, the Commonwealth again moved for a buffer zone, but with a larger area, again encompassing private property and traditional public fora, including public sidewalks and other areas. The Commonwealth also sought specific instructions to request police to use force to quash any dissent or protest. Yeah, they actually asked police to be able to be using reasonable force, like, I don't know what, tear gas? Kim John Cannone. 25. Without an opportunity for affected persons to intervene or be heard, Judge Cannone issued an order on March 25th, 2025, granting the Commonwealth's motion, asserting that the basis for the first motion warranted a larger buffer zone for the second trial, and expressly ordered that no individual may demonstrate in any manner, including carrying signs or placards, within 200 feet of the courthouse complex during the trial of this case, unless otherwise ordered by this court. This complex includes the Norfolk Superior Courthouse building and the parking area behind the Norfolk County Registry of Deeds building. The buffer zone shall further be extended to include the area bounded by Bates Court, Bullard Street, Ames Street, and Court Street. Individuals are also prohibited from using audio enhancing devices while protesting. See Exhibit C, which is the second prior restraint order. For the past several months, plaintiffs have been engaged in peaceful demonstrations with no adverse incidents. Such demonstrations took place in the location that is within the buffer zone of the second prior restraint order. For example, plaintiff Jason Grant, here's his picture. If you're just listening, you might want to look at the screen, but not if you're driving. For example, plaintiff Jason Grant peacefully demonstrated on the sidewalk next to the courthouse, holding signs reading, "Judge Bev is conflicted and Bev's court is a clown show." Regarding and with images of DA Marcy and Judge Cannone. Hold on. Let's give Jason Grant his due. Here's Jason Grant holding up his signs. Judge Bev is conflicted, and then Bev's court is a clown show. And then he's got a picture of Judge Bev or Judge Cannone with green hair and I think what appears to be some clown makeup on. But, you know, freedom of speech and all, right? And gave her some nice contouring, actually. Face looks very, very slim in that picture. Okay. 29. Such demonstrations were specifically about Judge Cannone and occurred during trials presided over Judge Cannone. And remember, this was after the first trial was long over. This is in the winter. This is like November of 2024. This was not even during the first Karen Reed trial. 30. There were no disturbances, incidents, nor interference with any of the trials taking place, but Judge Cannone was apparently embarrassed and annoyed by people protesting against her. Nevertheless, nobody's rights were impeded upon, and not one complaint was received that the plaintiffs are aware of. LB says she looks better with green hair. And somebody said that was Judge Beveridge's, Cusco, that was Judge Beveridge's St. Patrick's Day look. Those are funny. You are called the Snark Tank for a reason. Mudrucker chimes in with clowns to the left of you and jokers to the right, stuck in the middle with Bev. Oh, wow. That's hilarious. Because no matter which way you look at that picture, it could be. And there's Marcy to the left and Judge Cannone to the right. And it says conflicted. Clowns to the left of me. Jokers to the right. Here I am, stuck in the middle with you. Well done, Mudrucker. Plaintiffs wish to continue their Plaintiffs wish to continue to demonstrate, including criticizing Judge Cannone off the grounds of the said courthouse complex, but within the buffer zone during the second trial. Plaintiffs reasonably fear that Judge Cannone will attempt to hold them in contempt if they engage in such demonstration, or will otherwise attempt another unconstitutional act to suppress those who would criticize her publicly. Plaintiffs reasonably fear that the Norfolk County District Attorney's Office, under the control and direction of defendant Marcy, will seek their prosecution for violation of the order if they engage in such demonstration. And I would submit to you, they're right. They will be arrested. They will be thrown into that paddy wagon that you guys told me about that's lurking around out there. Children, I have candy. I got to find that guy, that child kidnapper from Chitty Chitty Bang Bang. Put him on the next thumbnail. Note to self. As Dedham police officers took action to enforce the buffer zone order during the first trial, plaintiffs reasonably fear that the Dedham Police Department, under the control and direction of defendant Entremont, or D'Entremont, will arrest them for violation of the second prior restraint order if they engage in such demonstration. And they are correct. As Massachusetts state police officers took action to enforce the buffer zone order during the first trial, plaintiffs reasonably fear that the Massachusetts State Police, under control and direction of defendant Noble, will arrest them for violation of the second prior restraint order if they engage in such demonstration. Here are the causes of action. Count 1. Violation of the First Amendment to the U.S. Constitution, declaratory judgment, and injunctive relief. Plaintiffs, and then repeat and reallege. 37. The second prior restraint order is facially unconstitutional. It is content-based regulation of protected speech in a public forum that cannot withstand strict scrutiny. Oops. While the Supreme Court has upheld a statute relating to picketing or parading near courthouses, it has not approved of a 200-foot buffer zone with an additional larger ill-defined area. Contrast Cox v. Louisiana, which is a 1965 U.S. Supreme Court case. It is over-inclusive. It includes speech in private businesses and homes and in traditional public fora. And it is under-inclusive as it does not regulate other forms of speech directed at potential jurors, the ostensible fair trial reason given. The second prior restraint order purports to address noise and to minimize prospective jurors' exposure to viewpoints about the Reed case, but is targeted solely to speech in the ambit of the Reed case when Judge Cannone and the Superior Court routinely conduct jury trials without such restrictions. Judge Cannone could have taken measures to reduce jurors' exposure to noise in public speech without imposing content-based restrictions. The second prior restraint order is unconstitutionally vague. Plaintiffs cannot ascertain where they may not demonstrate, as the purported bounds are not bounds at all. Plaintiffs cannot ascertain exactly what speech is prohibited. It is unclear if they can wave political signs that say, vote against DA Morrissey, or Judge Cannone is corrupt. Look, this attorney's great. I love how he got that in there. 41, the second prior restraint order is an unconstitutional prior restraint on speech. The second prior restraint order is unconstitutional as applied. Defendants have been purposely targeting people like plaintiffs who dislike Judge Cannone, and there is nothing that suggests that they would threaten anyone siding with the prosecution or supporting Judge Cannone. Plaintiffs have been injured or reasonably fear imminent injury by these constitutional violations, and plaintiffs are entitled to relief. Therefore, plaintiffs are entitled to a declaration that the second prior restraint order is unconstitutional, and they are entitled to an injunction against all defendants prohibiting enforcement of the second prior restraint order. An injunction is something that you want the court to order them to stop doing. Count 2. Sue says Mark Randazza is King Snark. He's the best, and I love debating him and Jay. That's cool. Repeat and reallege. 46. Defendant's conduct of issuing and enforcing the second prior restraint order is unconstitutional and violates plaintiff's rights to due process of law under the 14th Amendment. So this count 2 is a violation of the 14th Amendment to the U.S. Constitution under 42 U.S.C. 1983, due process. Prior to being deprived of their rights to speak freely and to assemble, plaintiffs were entitled to due process. There was no hearing, no opportunity to be heard, nor was there any due process whatsoever. There was merely an arbitrary and capricious action designed to harm plaintiffs and others issued by one person on account of anticipated First Amendment protected activity. Judge Cannone's second prior restraint order was issued in the absence of statutory authority or inherent authority over persons not brought within her jurisdiction through process. Judge Cannone's second prior restraint order was a usurpation. It was a usurpation. It's not a word you see very often. Usurp, you'll see, but not usurpation. A usurpation of legislative and regulatory functions, not a judicial act. Judge Cannone has no authority over what non-parties to a proceeding may do off a courthouse property, let alone on private property or traditional public fora. The Massachusetts Constitution does not empower Superior Court justices with explicit or inherent authority to regulate private property or traditional public fora in the way they might regulate courthouse property. No Massachusetts statute empowers Superior Court justices with explicit or inherent authority to regulate private property or traditional public fora in the way they might regulate courthouse property. Oops. Plaintiffs have been injured or reasonably fear imminent injury by these constitutional violations, and plaintiffs are entitled to relief. Therefore, plaintiffs are entitled to a declaration that the second prior restraint order is unconstitutional, and they are entitled to an injunction on the second prior restraint order's enforcement. Demand for trial by jury. Plaintiffs hereby demand a trial by jury on each claim asserted or hereafter asserted in the complaint, and on each defense asserted or hereafter asserted by the defendants. Prayer for relief. It just basically means, what are you looking for? Wherefore, plaintiff asks this court, A, a declaration that the second prior restraint order is unconstitutional under the First and 14th Amendments of the U.S. Constitution. B, a declaration that enforcing the second prior restraint order is unconstitutional under the First and 14th Amendments of the U.S. Constitution. C, a preliminary and permanent injunction enjoining each defendant from interfering with plaintiff's right to lawfully engage in constitutionally protected expression and activity within Dedham, Massachusetts. D, to award plaintiffs their reasonable attorney's fees, costs, and expenses pursuant to 42 U.S.C. 1988 and any other applicable law. And E, to award such further relief as this court may deem, honorable court, may deem just and proper. XOXO, dated April Fool's Day, but this is not a joke. Mark J. Randazza, J. Woolman, Randazza Legal Group in Gloucester. I'm going to say Gloucester because you guys have told me that the easiest way to pronounce anything in Massachusetts is you said this, not me. The laziest way to pronounce it is usually correct. So I'll say Gloucester. And Mark Trammell, the Center for American Liberty in Pittsburgh. Well done, my friends. Well done. And then they each personally signed a verification. So they're not looking for any money damages here other than their attorney's fees and costs. They're looking for an injunction and a declaration that Gloucester, a declaration that the judge's order is unconstitutional. Will they get it? I don't know, but I'm intrigued. I'm intrigued. Are you? There was a dopey, hold on, something dopey this morning. That I saw on the cesspool of Twitter. Yeah, and this is, this is what you call like Twitter legal analysis. By the one who will not be named on this channel until now, that I'm naming her because I have personal beef, and because I think that she works for the district attorney's office. Jennifer Coffindoffer tweeted today. I think it was yesterday actually. A federal suit was filed against Judge Cannone for the 200-foot buffer zone she imposed. This happened in the first trial as well, and they lost. And look, lost gets a capital L because I guess it's also a television show. You know I'm a grammar snob. You know I appreciate punctuation and proper capitalization and spelling. Lost has a capital L. I know you've been naming her a lot on your channel where her name isn't allowed lately. It's because I'm so happy that the defense is calling Garret Wing. Because the whole reason that I did that show with Garret Wing is because of her. So if the trial is won on Garret Wing's testimony, she can blame me for that. And then she says, I think they will lose again. Because, she's not a lawyer. Judge Cannone is doing a great job. No one is happy with all of her rulings. I will forever give pause to the fact that no sanctions were levied against Alan Jackson, David Yannetti, and Elizabeth Little for lying to the court. Yeah, nobody asked your opinion and nobody cares what you're giving pause to. I believe those sanctions will come after the trial concludes, as well they should. See, here's the thing about her. She knows everything before everybody else does. And she's been specifically pointed out as one of 3 people that is being leaked information by the district attorney's office. Jennifer Coffindoffer, not so confidential informant, mafia masshole, Kate Peter, and Kevin Lenahan, Yellow Cottage Cheese, have been named by Betterow in his letters or his lawsuits or whatever, there's papers out there. That's why they had to ask Judge Sisitsky for an extra protective order, because there's been leaks. It's been leaking like a sieve over there at the Norfolk County DA's office to those three. And it's so funny because now, if I haven't watched in a while, but when I was on Court TV in January 2024 with her twice, and after that, I was like, I'm never. If they call me, I'm like, who else is going to be on? Yeah, no. She said at the time, you know, the basement was ripped up because they had a plumbing leak and an insurance claim, and the dog wasn't rehomed. Everyone knows where the dog is. The dog is in. I think she even said at the time the dog was in Vermont. Like, she knew everything before it was public. Just like Mafia Masswell Kate Peter knew when Aidan Kearney was going to be arrested, and has tweeted out a lot of stuff. And I've seen the text messages. And Coffin never said, I've seen the messages. They're going to be in trouble. I'm sorry. How did you see them? If sanctions come after this trial, as predicted here, that'll be crazy that they're still leaking information to someone who's been specifically named in the papers, right? And then she says, a very light turnout for Karen Reed on day one. I don't know. You guys were there. You let me know. Right, Peggy. You don't jackhammer up a cement basement over a water leak, right? She says, they actually said the Pledge of Allegiance, but began with the words, our Father. That was pretty funny. It's not a proper sentence. And then, of course, she hashtags it Karen Reed and hashtag Karen Reed trial. Posts some pictures. Oh, I see Mazza in that picture. There's Mazza. Is this picture from yesterday? Does anybody know? And then protects her tweets so nobody can comment on it unless she follows you or you are mentioned in her tweet. See? So there's that. And every day she spews vitriol and hatred for Karen Reed on her Twitter page. It's insane. It's insane. So does anybody know if that was a picture from yesterday? Elby says, so she posted clown photos too. Oh, it looks like an old photo. Read it is there. Okay. Brian Albert Jr. lives with Ryan Nagel, says Allison. Really? They're roomies? Interesting. That's old. They're sleeveless. Oh, you don't know who she is? Oh, I don't know if she has her picture in her profile picture. No. If you Google it, it'll come up. Actually, I might have one. Hang on. She was in the documentary recently. Okay. Apparently, they have amended their order on media not being allowed to talk about what the jurors look like, because they're allowed to say race. They're allowed to see race and gender. But that's really kind of it. Yeah, look at that lousy engagement. Right. Dumpster fire. Proctor's Missing Pension says, 2 of those 3 names you read, Melanie, are speculating that potential jurors are reaching out to Turtleboy to get advice to fill out the questionnaire. Oh, really? Boy, they're desperate, huh? Let me know what you want to look at next. Here's your choices. Your choices are, I'll do a poll because we're going to do them all anyway. Hold on. I don't really need to do a poll. If you want to do Aidan's motion to be exempt from the sequestration order, Just write Aidan in the chat. If you want to do the opposition to the Garret wing motion, just put wing in the chat. And I'll see then that's the one we'll do next. Goldie, I'm going to save that one for later. Kyle, judges like me to be fair. Are you starting, Bev? Thanks, Kyle. Iris, the fact that Karen Reed, Ingolf Turk, Sandra Birchmore, and Brian Walsh are all in the same melting pot of Massachusetts is insane. Yes, what's in the water in Norfolk County? What's in the water? Thanks, Iris. Don't drink the water if you go there. Maybe just don't go there. Noel, DUI guy talked about 3 ways to get Ingrid's judge off the case. Wish some attorneys would have get together and get it done. Love your channel. Who's Ingrid? Actually, I'm doing a collab with him coming up soon. We're going to pre-tape it. So that's going to be a lot of fun. We've never streamed together, Larry and I. So thank you, Noel, for your super chat. USMC Semper Fi, cowgirl. How's it even possible to charge her with no accident report? According to MSP lab request form, Commonwealth can't get the BAC they want without a report either. That's interesting. Because we're in the upside down Narnia, inside out Massachusetts Twilight Zone of Norfolk County. That's why. And Monge, thanks for your time. When the defense gives closing arguments, can they mention if they are confused what they are allowed to do during deliberations, like sending notes or asking about the juror form? That's a great question. I mean, the judge is supposed to instruct them on that stuff. Maybe they can ask the judge to instruct the jury. Right? Because based on all of the appellate rulings, there is no requirement for the judge to ask them about partial verdicts. Perhaps they can ask her to instruct them on that. Good point. Tracy must be her because the FTR system is designed for readbacks. Yeah. So she's got discretion. She's the gatekeeper. She loves to say that she's the gatekeeper. The gatekeeper to hell. The gatekeeper to hell. Oh. Okay, I think we're getting a lot more wings than Aidan's, but we're going to do both. So we'll do wing first. Love it here. Thanks, Mrs. Buckeye. Appreciate you for being here for 7 months. Abacus Flinch, I hear these juror number call outs, and all I can think of is Tommy Tucson. Thank you. Yeah. Greg, they always tell me it's a rewarding one. Quote from the judge. Yeah. Are you sure you were talking to the jurors on your cases? Thanks, Greg. Couple of new members, Brenda and Patty. Welcome. Canadian Gooner, thank you for your super sticker. Coffee Girl, 15 months. You're an OG too. Thanking me for being a justice warrior. I appreciate you. New Hampshire woman, give my imaginary best friend Melanie a like. Thank you so much. Thank you so much. Brennan's Thoughts is here and became a member, as did Bev's Panic Attacks. Thank you so much. Destiny says, if you have a second, can you give me any major updates that happened recently? Went through a horrible breakup in January, and I've been grieving. I'm behind on everything. Thank you. I'm sorry, Destiny. I'm sorry. Scroll through Instagram and find every single post you can find about narcissism and gray rock method, and it'll make you feel better, I think. I wish I could help you heal faster, but I've got no secrets. If anybody in the chat does, feel free to give Destiny some advice. Major updates. The motion to dismiss was denied, even though there may have been some jury tampering on behalf of Trooper Fanning, who testified yesterday in another case, because he may or may not have been involved in policing the jury because of some things that came out about a juror that got kicked off the jury who was very pro Karen Reed. And also the other argument for dismissing the case is that the Brady violations of the prosecution not turning over all the Sallyport video is so egregious. The only proper remedy is you got to dismiss the case. And the judge said in her infinite wisdom, well, there's no prejudice because she gets to have another trial. As if she can't figure out that the effing prejudice was the fact that she was tried in the first place without all of that evidence that could have exonerated her. I advise you to go watch my stream on that. My head popped off at least 17 times. So I'll give you a couple places to look. Start with that one, the stream where I read the decision on the motion to dismiss. And then if you see any other titles that pique your fancy, maybe people in the chat can direct you on the ones to watch, because it's a lot of shenanigans, tomfoolery, and ballyhoo going on here. But that, I think, is the most egregious one. Prayers up for Destiny. If Craven, my BS and disgust me to strain the second she opens her mouth, I too have grave concerns for Karen's fate. Don't worry, you guys. It's going to be okay. Her team is amazing. They deal with this kind of BS every day in courthouses all over the country. They're used to it. It's going to be okay. Patricia, and they're going to kick ass at trial. They're going to shred every single one of the Commonwealth's experts in a way that is going to be so delicious and delightful to watch that it's really going to be must-see TV. So, silver linings, right? Let's just hope they're picking the right jury, because that is the key to this case. Worst case, it's another mistrial. I never see a conviction happening, no matter how many times they choose to retry her. Thank you, Patricia, for hanging out for 9 months and for your thoughts that you hate the judge's bias. Be humble, fair, and kind. I traveled from the UK, South Africa, and wanted to catch up with your Karen Read updates. Opened YouTube at the hotel, didn't sign in, and Melanie Little was top of the search results. That's amazing. The world is watching you, dishonorable. But thank you so much for telling me that. That is so cool that you were in South Africa, and that is really neat. Thanks for telling me. According to Woo, thanks for your 5. If the Commonwealth is alleging a car accident, one would think an auto claim was reported. Nope. They are being sued, though. There's a civil case pending, a wrongful death case. The O'Keefe's against Karen Read, the Waterfall Bar, and C.F. McCarthy's. The civil suit, I have at least one show on the civil case that I've done, and I say it's going to be very difficult to prove a motor vehicle accident without a crash report. That case has been stayed, so it's sort of frozen. They're not allowed to depose Karen until after this case is over. I'd be curious to what Karen Read's insurance company's investigation showed. I don't think they did one. Because I don't think the claim was ever paid or even filed. And it sounds like you might be in insurance. I know that I do have a lot of auto BI adjusters in the chat, and also property damage adjusters. And they work for major carriers like Liberty Mutual, State Farm, Allstate. They're like, I never would have paid on this case, ever. There's no proof there was an automobile accident. And if you live in a no-fault state, as New York is, if you are a pedestrian hit by a car, your auto insurance pays the medical bills, not your health insurance, because we are a no-fault state. So, had they filed this case properly, Karen's auto carrier, if you're in a no-fault state, which I don't know, but I think you guys say that, oh yeah, so Miss Jessica used to be an auto adjuster in Massachusetts. If you're a pedestrian hit by a car, the driver's auto policy picks up your medical bills. It doesn't go through health insurance. It'll get rejected if it goes through health insurance if it's a car accident in New York. And Massachusetts is also no fault. And they also cover death expenses. There's some sort of death benefit usually, and maybe some funeral expenses. I don't think they ever made that claim. So they're going to have a lot of problems. Those of you who are in the chat and you are insurance adjusters, tell me if you would have paid on this claim. And I think they're defending it to hell and back, and I think that they should. I don't know who her carrier is, but they're not going to pay. They're not going to pay. And now that she's got the Waterfall and CF McCarthy's on her side because they're all defendants, I mean, good luck with that. Thank you. According to Woo. Right. According to Woo, it says never in a million years. Colin Albert did it. Thanks for your 5. You might get arrested if you're in Massachusetts. I'm just saying. You might want to change your name. I hope the feds are investigating corrupt Cannone and the greasy meatball blocking evidence they provided and vetted. From your mouth to God's ears, Virginia is so happy when she can spend her workday. She's been with me for 12 months. She's an OG too. Just ordered your merch, Twilight Zone. Awesome. Don't forget to click the coupon at the top. It's 20% off today. And I've got the link pinned in the chat. Hate is a strong word, says another Vice. But I must say I hate. I hate the judge. I mean, listen, it is. It's strong. And sometimes, sometimes there's a reason. Thanks for hanging out for 13 months. Becca became a member. Thank you. Melissa is here again. I'm worried jurors saying they haven't heard of this case being plants. A few accusations going around already. I'm trying to believe in the system. Don't believe the hyperbole and rumor out there. And just, I know it's hard. It's hard to believe. It's hard to believe, but we did see a couple of great things happen in Massachusetts lately. So remember, we watched Brian Camp be acquitted by his amazing attorney, Tom Kokanowski, who's got another big case that's going to be in court on Monday. We're going to cover it. It was a shooting in Hyannis. Got the documents on that, where the person who was shot exposed himself to this guy's wife. She was walking alone from the bar back to the car. He was sitting in the car. We saw Brian Camp acquitted. We saw Penny McGee acquitted in a bench trial by Judge Cannone, which, I started during the Penny McGee trial to give her a little more slack. I'm like, okay, she gets it. She understands the law. And she dismissed that case. She acquitted her from the bench. Didn't even go back to deliberate, nothing. It was wild. And we saw Daniel Penny in New York also acquitted. So sometimes you just got to believe. In this case, I know it's hard. It's hard. It gets really frustrating. God, my head is popping. Excellent, excellent username. Heard the Alberts or their associates are paying a PR firm to flood social media outlets with guilty messages. Well, it's called astroturfing. There's a name for it. I didn't know that it was called astroturfing until I recently tried to very unsuccessfully cover the Baldoni Lively Michigas. And then after one or two streams on that, I was like, I'm never touching this again. You think this case is divisive? You ain't seen nothing yet. And I don't suggest that you watch anything having to do with Baldoni and Blake Lively. But astroturfing is a thing where PR companies do that. And it's either through bots or people who are paid to make it look like real engagement, to go out there, spread the message. I can't speak to the truth or veracity of that. Sounds like a rumor. I don't know where they would get the money to pay for that, but it is something that is done by PR firms. It's now we know. Ducks in a better row. Oh, excellent. Excellent name. $11.58 is, quote, and to a moral certainty, a Massachusetts thing. Everyone has different morals. It seems like a hedge to actually allow jurors to be biased. Meanwhile, your dedication is appreciated. Thank you. There are a handful of states that use moral certainty, not a New York thing. But, Massachusetts is like still in pilgrim times with, a lot of their laws and stuff. So it's not every state that uses to a moral certainty, but Massachusetts is one of the few. True Crime Junkie became a member. Thank you. Welcome. Nicole Hoban Accounting. Ugh, Bev is so biased and boring. Thank you. We know. Bev's Panic Attack became a member. Welcome. Breenan's Lack of Self-Awareness. A deliberating juror from Trial 1.0 personally delivered Dunkin' coffee to supporters outside court Tuesday. If you know, you know. Free Kearney, I heard that, and that's pretty awesome. That is pretty. Thank you, Rachel. Rachel, thank you for your super chat. Massachusetts does not require CLE. I heard that too for the first time, like yesterday. That's insane. Are there other states that don't? I do not know. I'm sure a Google search would tell you, but I thought that was crazy too. New York does. Every 2 years, you have to have, 28, 29 credits. Nowadays, you can do it online. You used to have to physically go to these things. And then after you watch it online, you got to fill out like a little questionnaire, like a little test. So the answer is, I don't know if Massachusetts is the only one or more than one. All right, let's take a look now at the opposition filed by the defense to the Commonwealth's motion to preclude Garret Wing. And this is Thaya. No, docket number 660. Docket number 660. And, leave it to Alessi, because really, chef's kiss to his writing style. Okay. Hold on, I need my chapstick. Hold on one second. Anybody else relate to this? You know how like you have your car chapstick? Well, this one's Aquaphor. Aquaphor is very good, but it doesn't really have SPF in it. But it's okay because it's raining today. You have your car chapstick. I got a chapstick in every purse. I got the nightstand chapstick. I got the makeup table chapstick. And then the chapsticks start to get all the way down to the nub, and then you start moving them around, and then you're lost because your nightstand chapstick is gone, and you have to like dig your fingernail into this to get it out. It's really a pain in the neck. 100%, right? 100%. You got them everywhere. You got them in every purse. Then you change your purse and you don't have your chapstick and you're like, oh. Then you go on vacation and you need the chapstick with the SPF in it, but it's hard to find. And that one's always like $20, $15. Ridiculous. Okay. Misophonia friends, I will mute my mic for you. You all teach me so much, such as like misophonia is a thing, which I never knew. And also it can be debilitating, you have said. So when I drink, I mute my mic because, you know, I'm here for you. Courtesy. Okay. Defendant's response to Commonwealth's renewed motion in limine to exclude expert testimony of Garret Wing. This was filed yesterday, April 2nd, 11:02 a.m. Oh, thanks. You like that? Thank you. Thank you very much. Chapstick can be addictive to the lips. People say that. I use Aquaphor. I don't think Aquaphor is addictive, but some of them with, the scents and stuff can be. I don't use actual chapstick. To me, that's like wax. My father always had a black chapstick in his pocket. It was like, he didn't like the smell. It's waxy. Now comes the defendant, Karen Reed, in the above captioned matter, and respectfully request this court to deny the Commonwealth's renewed motion in limine, or lemonade, as the closed captions called it one day, to exclude expert testimony of Garret Wing. Footnote 1. Defendant does not waive and reserves any argument put forth against Commonwealth's original motion in limine to exclude expert testimony of Garret Wing. The entirety of the Commonwealth's renewed motion appears to be based upon the inaccurate premise that the defense intends to call Lieutenant Garret Wing, remember when we read the motion, I think it was yesterday or the last stream, Brennan calls him Mr. Wing, Lieutenant Wing, and then Dr. Wing in the final paragraph. So it is Lieutenant. His entire motion appears to be based upon the inaccurate premise that the defense intends to call Lieutenant Garret Wing as a Sir rebuttal expert to Commonwealth expert witness Dr. James Crosby. In actuality, defendant intends to call Lieutenant Wing as an expert witness in her case in chief. That's what I said. And not as a rebuttal witness to Dr. Crosby's testimony. On this basis alone, the Commonwealth's motion should be denied. That's exactly what I said. Brennan's motion did not contain anything attacking the qualifications or the expertise of Garret Wing, who we now know is a lieutenant. Didn't say he had improper methodology, lack of qualifications, shouldn't be regarded as an expert in the field. None of that was in the motion. It was just that, no, we don't do Sir rebuttals. There's no case law for it, and you're not going to get it, so you shouldn't be allowed to call him. And I said, who said they're calling him as a Sir rebuttal witness? They can have him in their case in chief. And that is exactly what they intend to do. As the defense has stated previously, on June 18th, 2024, this court determined that only a medical doctor could opine on the medical cause of an injury to a human. Remember, that was during the voir dire of Dr. Rentschler, because part of Dr. Rentschler, Crash Daddy Rentschler's analysis was showing that the injuries to John O'Keefe were not sustained in a car accident and that the damage to Karen's vehicle was not caused by hitting a body. And he's got a lot of expertise in that. This is what he does. He's a biomechanical engineer. And she said, yeah, no, he can't testify about the injuries because he's not a medical doctor. That was her ruling in the first trial. That was on June 18th of 2024 during the first trial. Until March 6th of 2025, the defense therefore operated under the impression that only medical doctors are able to testify as to the medical causation of an injury to humans, including injuries caused by dog bites and or claw marks. Because ipsy dixit, that's what she said last time. This court's March 6, 2025 order caused the defense to revisit the topic of the wounds to the right arm of the decedent, including potential witnesses, expert in dog-inflicted wounds on humans who are not medical doctors. At no point did the defense ever express that Lieutenant Wing is intended purely as a rebuttal witness for Dr. Crosby, rather that the court's determination on Dr. Crosby, including the defense's motion for reconsideration of the March 6 order, would inform defense strategy regarding Lieutenant Wing. Right. Here's what he's saying. You made an order on March 6 saying that Crosby could testify. We asked you to reconsider that order based on the fact that it was absolutely wrong, not only under the law because methodology, but also because you ruled that way during the first trial. So we asked you to reconsider it and you said no. And so that made us rethink. Okay, well, if we can call witnesses that don't have to be medical doctors to talk about dog bites, let's call the guy that Melanie Little had on her channel in January of 2024, who was an amazing witness. And all of you have been saying that for over a year. Why can't they call Garret Wing? Why can't they call Garret Wing? And I've been telling you, listen, he's not the kind of witness that would be able to testify about causation of injuries because he's not a doctor. And that's what the judge said during the first trial. After I said it, when you guys were asking, like in January 2024, and then she overruled herself, let Crosby in. So they are now like, okay, good. Open season. We'll call whoever we want. And Garret Wing is the guy. And he's a lot more experienced than Dr. Crosby. I'll tell you that much. Additionally, until the March 6 order, several questions remained about how the defense would proceed relative to the Commonwealth's treatment of Dr. Crosby. At oral argument on March 4th, 2025, the Commonwealth verbally stated that it did not intend to call Dr. Crosby in their case in chief and intended only to call him as a rebuttal witness against the testimony of defendant's expert witness, Dr. Marie Russell. Dr. Russell, you may recall, I'm going to break from script for a minute. You may recall, Dr. Marie Russell, highly qualified, ER doctor. She's conducted thousands of autopsies. She worked as a prison doctor, has treated thousands of dog bite patients in both the ER and prison. Because remember, Garret Wing is the guy training the canine dogs to bring down the perp. Subjected Dr. Russell to a full 2-day voir dire prior to the retrial. 2 full days. We had secondhand embarrassment for Brennan. No voir dire for Crosby, who nobody really even knows what he's an expert in because the Commonwealth didn't tell us. And although they said he's testified before, in many cases, we don't know what he's testified about or what field he's been qualified as an expert in. And that will be great fun if they do call him on rebuttal and then he's sliced to bits by Bobby Alessi's. Like, we should call him like Bobby Scissorhands. That's it. I'll allow it. Bobby Scissorhands. He's going to take those Edward Scissorhands fingers and he's just going to slice them. Or, like kind of like the Nightmare on Elm Street guy. Didn't he have like knives for fingers too? I don't remember. Anyway. She had 2 full days of voir dire. We're in the land of I don't even know what. Yeah, most qualified and vetted expert ever. Dr. Marie Russell, who was in the D section for doctor in the witness list that she read to the jury 3 days in a row. Go figure. The court asked, so just to be clear, the Commonwealth does not intend, if I permit the testimony, does not intend to call him in your case in chief. The Commonwealth responded, absolutely not. According to the Commonwealth renewed motion, Exhibit B. However, the court's March 6th order contained no such limitation on the scope of Dr. Crosby's testimony for the Commonwealth to call him only as a rebuttal witness. Due to the lack of a memorialization of the Commonwealth stipulation, the defendant reasonably assumed that the Commonwealth could call Dr. Crosby in its case in chief should it choose to. Oh, well done. See what he did there with his wordplay? Your order wasn't clear, Your Honor, and therefore we can do whatever we want. Alessi is going to go full Kruger on Crosby. Thank you, Teacup Kraken. Thank you for verbalizing for me when I haven't had enough coffee. You didn't put it in your order, Your Honor. So we know how you've been ruling, even though Alessi is new to the team. Wicked smart. We know how you've been ruling for the past 3 years plus that this Michigas of a case has been going on, and therefore we don't trust you. We don't trust you to hold Brennan to the statements he makes in open court because we've seen him lie to you in open court and wave about papers where he flagrantly accused the defense attorneys of committing heinous, nefarious ethical violations, which caused you to have a mental breakdown and grave concerns. And then he kind of sort of corrected the record and said, yeah, no, we didn't. The defense gave these to us, not the U.S. Attorney's Office. And then, nothing happens to him. He just gets up and lies. So we don't trust you to keep him at his word. And so therefore, what do you think she'll do now? You think she'll just amend her order to say they can only call Crosby in rebuttal, and then you're not entitled to a rebuttal, so you can't call Wing? Again, Magic 8 Ball. We have the Magic 8 Ball right here in case we need to know an answer of what we think the judge is going to do. For the first time ever in writing, and after receiving the report of Lieutenant Wing, in its renewed motion, the Commonwealth states that it, quote, intends to offer Dr. Crosby only if necessary to rebut the testimony of Dr. Marie Russell. The defendant intends to call Lieutenant Wing as an expert witness in her case in chief. Lieutenant Wing's decades of knowledge, skill, training, and experience, together with his documented methodology, qualify him on the subject of dog-inflicted wounds on humans. To cure any perceived complaints by the Commonwealth with Lieutenant Wing's original report, the defense will provide an amended report of Lieutenant Wing, which will remove all references to Dr. Crosby. Oh man, I wish we could see that report, because I bet that Garret sliced up James Crosby in his report and refuted every single point that Crosby made. Oh, that must be a work of art. The defense expects to provide this amended report to the Commonwealth within the next 5 calendar days. As the defendant intends to call Lieutenant Wing as an expert witness in her case in chief, the discussion of law on page 2 of the Commonwealth's renewed motion is inapplicable. He's right. Because all their case law talked about was whether they were entitled to a surrebuttal. But here's where he's going to get spanked. This notwithstanding, and in reference to the Commonwealth's incorrect assumption that the defendant intends to call Wing as a rebuttal witness to the testimony of Dr. Crosby, the Commonwealth states in its renewed motion that there is no sub-rebuttal, we pointed that out too, in Massachusetts courts. This statement is accompanied by no authority, and it is incorrect. And then he goes on to cite 1, 2, 3, several cases from Massachusetts, which allowed surrebuttals. Hoffman versus Houghton Chemical, allowing surrebuttal witnesses. The judge limited Houghton to one surrebuttal witness only. Commonwealth v. Brown, 2003 case, again allowing surrebuttal witnesses. Quote, on surrebuttal, Brown testified that 2 Walkmans were returned to him after his arraignment. End quote. Wow. 2003. Were Walkmans still around in 2003? Huh. Oh, the old Walkman. Remember the Walkmans? They had put a cassette tape in. Those are great. In fact, expert witnesses are explicitly allowed to testify in surrebuttal in Massachusetts. See Commonwealth v. Brown, 2007. A defense surrebuttal expert who examined the same test results reached a different conclusion and testified that Brown was not malingering. Commonwealth v. Benson, 1994. Defendant was allowed to rebuttal by a psychologist who sought to undermine some of the premises on which the Commonwealth's expert had relied in reaching his opinions that the defendant was criminally responsible. Just more evidence that Hank's paralegal hates him because nobody found any of these cases. Or they found him and they just ignored him. That's why they had no case law in their motion. Therefore, even if the defendant did intend to call Lieutenant Wing as a surrebuttal expert, there's no Massachusetts law the defense could locate that would prohibit her from doing so. Indeed, there is contrary law in her favor on the issue. So disingenuous. Yeah. Leslie Scissorhands. God, my head is popping off. I'm loving that username today. Green-eyed Southern girl says, oh my God, my childhood is in the Smithsonian now. I'm old. That's hilarious. Conclusion. For the reasons set forth here in Spank, the court should deny the Commonwealth's renewed motion in limine to exclude expert testimony of Garret Wing. The defendant intends to call Lieutenant Wing in her case in chief, not as a rebuttal witness. As of the court's March 6th order allowing Dr. Crosby to testify as an expert, experts are no longer required to be medical doctors to testify about the medical causation of injuries. Yeah, because you said so, Your Honor. Lieutenant Wing's decades of knowledge, skill, training, and experience, together with his documented methodology, qualify him on the subject of dog-inflicted wounds on humans. Finally, and in the alternative only, surrebuttal witnesses are allowed to be presented in Massachusetts. For these reasons, the court should deny the Commonwealth's motion. Okay, let's see. We'll ask the 8-ball. Will the court allow Garret Wing to testify in the case in chief? And it says, it is decidedly so. All right, Magic 8-ball, I'm going to rely on you. The Magic 8-ball says that Judge Cannone will allow Garret Wing to testify. We don't really know what's going to happen because I wouldn't put bets on it. XOXO, Robert Alessi, Bobby Scissorhands. And that was just filed yesterday. And that is docket number, for the record, docket number 660. Docket number 660. Let's go to the chat, see if we have any questions on that before we move on to the next thing. Random thoughts. Has a court ever ordered a free speech protest with signs? This is going beyond blank, fill in the blank. Thank you, Random Thoughts. Super chat. Kansas Sofa juror, is there any chance this lawsuit file would ever get reviewed by higher courts or ethics committees? It would. If they lose, I'm sure they'll appeal it. This is what Randazza does, right? He's a First Amendment guy. And we'll see what happens with it. I mean, according to Jennifer Coffendorfer, they're going to lose because, you know, she's a lawyer. Katie Leone, hey Melanie, can you please explain this to me? If a jury can't convict, how is a retrial not double jeopardy? Well, because they weren't convicted, and so that's called a hung jury. And they are allowed to be tried again. If you are acquitted, you are not allowed to be tried again. So it's like they don't get a second bite of the apple if you're acquitted. Even if they come up with more evidence or something like that, they can't retry you. Does that mean the prosecution failed to prove guilt? No. Doesn't that mean? No, it just means that the jury couldn't agree, that they couldn't come to a unanimous decision on guilt. That's what it means. Unfortunately. Thanks, Katie. That's a great question. Kelly, why so many witnesses from recused Canton PD? I'm 2 hours behind, but I want to say I have qualifications in dog behavior. This, in my opinion, enables me to say why a dog would bite, not say wound. Is the dog bite well done? Well done. And we also know that James Crosby often investigates deaths where people, mostly children, are mauled by dogs and killed by dogs. And that doesn't happen that often, right? That's why Marie Russell said, I have more experience than medical examiners with regard to dog bite injuries because it is rare that someone dies from dog bite injuries, right? Crosby's the guy who I think helps with the investigation after someone is already dead of a dog attack. He doesn't have to figure out what happened. They know what happened, right? Mighty Ducks, our rights don't end where Bev's fear begins. It's called a public square for a reason. It is public. Cannone is displaying Orwellian tactics. Yes, and that's been in some motions, and we have some users with Orwellian type usernames. Thanks, Mighty Ducks. And Mange, nothing to see here. Can people on private property and buffer zones put signs on their property and wear pink? No, I don't think they can. And that's what they're saying here. You're not allowed to regulate people's private property and tell them what they can and cannot do on their private property or in their own business. Great question. Thank you for your super chat. Miss Kitten Cakes, to have a juror actually want to join your defense team is wild. Thanks, Melanie. Yeah. Yeah, she was outraged about the injustices of the system. Thank you for your super chat. The water in Norfolk County contains White Claw. Thank you, Canadian Gooner. You can see it from all the way up north. Gettin became a member. Welcome. Welcome, welcome. Chloe Albert's revenge is here. I think the water's fine, but their solo cups are contaminated. Well done. Ipsy Dixit. Thank you for your super sticker. Isabel Park. Melanie, they have the document in the snow on YouTube. The documentary's up on YouTube. Okay, so for those of you worldwide viewers who could not get, Isabel's from New Zealand, you guys couldn't get the documentary, the documentary that was just streaming on HBO Max and Discovery ID. Apparently it is on YouTube per Isabel. Thank you, Isabel, for letting us know that. I appreciate you so much. Hang on 1 second while I pull up the next document, the Aidan Connie motion. Put that over there. Thanks, Isabel. My Mini 67 Narnia is not involved in this show. Thank you. Anna Laura Willems, thanks for your super chat. I'm waiting to get a new aorta surgery. After the surgery, I need a 1-week coma. I will rewatch everything through your channel. I love from the Netherlands. Love to you. Prayers up for Hannah. Best of luck. Sending all the healing vibes. You can do this. You got this. Thank you for letting us know so we can all pray for you. Prayer hands up for Hannah. Thanks, you guys. On top, thanks for your super sticker. Velo Ange, thanks for becoming gifted a membership. Thank you so much. Appreciate you. Did you say the zip-up hoodies run large? Yes, the zip-up hoodies run very large. Because I guess it's unisex size and they're super, super soft. I have two. I got the orange one, which is not really like a true orange. It's darker than it looks in the picture. And I got the whitish, like the ivory one, and I love them both. D says there's a rumor Qualin was selling illegal substances and John O'Keefe reported. No, that is not true. That has been debunked. It is not true. Thank you. But no, it's not true. It is not true. That's a rumor that was started by someone on the other side. And even Aidan has come out and saying it's Karen came out and said it's not true. So no, but thank you for your super chat. Shauna, thank you for your 10. Appreciate you so much. Isabel, Facebook will send kiwis to your channel because of me. Oh, thanks, Isabel. Love my kiwis. Baron Bombburst. Oh, that's like one of the characters in Chitty Bang Bang. Jody Mitchell is here. Not Joni Mitchell, but Jody. I simply cannot comprehend the fact that no one in media or government is asking why all this money is being paid to Brennan when they have an office full of lawyers. Yes, they have 50 lawyers. This is the hot potato case of Norfolk County. There is no conflict here. There was no reason for them to go out and hire a gun. Hank Brennan is a hired gun. They're paying him $250,000, right? It's insane. I don't know why they're not asking those questions either. They don't care about the answers, you see? Because if they cared about the answers, the reporter who went out and got the statement on a sofa from Michael Proctor's sister, Courtney, and wife, Elizabeth, when the day before it was announced that he was terminated by the Massachusetts State Police, if they wanted the real answers, they gave them the opportunity to speak out about that. Why didn't they go and knock back on their door after Judge Cannone threw Michael Proctor under the bus in her order on the motion to dismiss, blaming him for everything? blaming him for hiding the Sallyport video, blaming him for not turning it over to the district attorney's office. She really threw him under the bus. And if I was that reporter, I'd be knocking on the door saying, do you have any response to this? You told us what an honorable man your husband was. Aren't you outraged that they would do this to him? Hasn't your family been through enough? Why would the judge do this to you and your family? No, nobody did that. Chloe Albert's Revenge says, astroturfing Ryan Reynolds literally played a professional at that in the movie Spirited, so I'm sure it's present in his wife's case. I don't know. I didn't know the term astroturfing. I'd never heard the term before. That's what I was referring to. So this is why that's why I don't cover that case. I'd never heard the term. It was the movie that he was in, Spirited. Did they call it astroturfing? I don't know. It was a term that was new to me. Love my flip-flops. Thanks for gifting 5 memberships. You're the best. Thanks, Rebecca, for becoming a member. And Yanetti's Venus Blue Flannel. Oh, well done. So they got my free Karen Reed Cancun zip up. Bay County, Florida against Crosby. Yeah, Bay County, Florida. There was a recent death, right, where a child was mauled by pit bulls, and I think he was called into the autopsy. Is that what you're talking about? Thank you. I'm glad you like your zip up. Canadian Gooner, anti-Bev is poser. Love the green hair. Bobby Leslie's Slice and Dice, now open for business, says, OMG, I had to change my name. You were previously Reed's Bite is bigger than Chloe's, and now it's Bobby Alessi's Slice and Dice, now open for business. I will allow it. I will allow you to send me $5 to tell everyone, and that is amazing. I love it. Ashley Lawrence says, my sweater came today from the wheel spin. Oh, that's right. You won. We did a giveaway. We could do a giveaway today. You guys want to do a giveaway in a little while? We'll do another one. I'm so glad that you like it, Ashley Lauren. I'm so glad that you like it. I think we did 3 giveaways on that stream. You just have to be willing to give me your address, and I have to, and I can send you a prize. KOB, so many motions. Did she yet rule on allowing the crash daddies? She has said that they are going to be voir dired like the day before their testimony. So she hasn't really ruled on it because after their voir dire, she may say, no, they can't testify, which is insane. Because how do you know what, if you don't know whether they're going to testify, you can't address that in your opening. Because your opening is all about what the evidence will show. And my suggestion for the opening statement this time, instead of saying Karen Reed was framed, John O'Keefe was not hit by a car. The evidence will show John O'Keefe was not hit by a car. You are going to hear from 2 biomechanical engineers who were hired by an independent third party, if they're allowed to say that, who are going to tell you, because physics, the damages to Karen's car did not come from a pedestrian strike. The injuries to John O'Keefe's body did not come from a vehicle strike. They just didn't. And focus on that. But if they don't know whether or not they're going to be allowed to testify, they can't. And she's hamstringing them at every turn, and it's making me mad. Thank you, though. Alba Gamer 82. I hope the 8 ball is correct. Me too. Me too. Twilight Zone just went down the Twitter cesspool. The waste of time. I know it really is, right? Thank you for bringing us. So classy. I just lost brain cells. Don't do it. Don't do it. Thank you so much for your super chat. Yanetti's Venus Blue Flannel. Crosby was head of Bay County Animal Control. He was fired for animal cruelty. What? He's also known to change his protocol to match his testimony. He's trash. Thank you for your opinions. I can't confirm or deny that. But thank you for sharing that with me. We can look into it. Let's take a look at Aidan Kearney's motion. Does anybody know if this has been ruled on yet? Let's see here. Yeah, does anyone know if she ruled whether the McCabe's and Alberts will be allowed in the courtroom? I don't think she's ruled on that one either. Okay, you guys haven't seen anything on this? Okay, good. Then we sometimes we get like stream jumped Mm-hmm. Thank you, Lisa, for your Venmo from Attorney Wannabe. Surprised the questionnaire doesn't ask if jurors ever worked at McCarthy's or Waterfall. That's a good point too, right? Thank you, Sandra. Wanted to point out something in the Canton report. When Lank arrived at 34 Fairview at 6:38 a.m., Matthew McCabe was already there on page 89, but page 94 and going down all pages. Oh, interesting. When Lank arrived, Matthew McCabe was already there at 6:38 a.m. Is that why when Jennifer McCabe and Matt McCabe went to be prepped for their testimony by Tully in the middle of the trial that they didn't tell the defense about until after the trial was over or after her testimony, that they asked to see the dash cam footage of Matt and Jen? That is interesting. Thank you, Sandra. Olivia, I don't know if you're here. I don't know if you've run with that already. All right. Let us look at the motion. Oh, hi, Olivia. That is accurate regarding Matt McCabe. Well, that's interesting, right? So maybe he is on some of that dash cam footage, but I don't remember seeing him on it. Do you? Do you think it was doctored? Oh, it was in the audit report. And then she said, but to be honest, I don't know how reliable the audit report is. Huh. Okay, let's look at the motion by Aidan Kearney to be allowed to be in the courtroom. Let's take a look at this. And this is filed under Commonwealth v. Karen Reed. So it's filed under her case number. So, it should be heard by Judge Cannone, but, sometimes we get a mystery judge in there. We get a judge that nobody has never heard a motion in this case. Like we saw Sisitsky sit in on the Rule 17 motion to obtain the text messages between Karen and Aidan, and then Cosgrove turned over a whole bunch of other stuff that included communications between Yannetti, Yannetti and Karen, and Sisitsky was like, yeah, no. Hold on. The docket is slow today. Wicked slow. Have I seen the recent Facebook post regarding John's body? No, I'm not involved in any of those Facebook groups, and I don't even go on Facebook hardly ever. And it's made my life 100 times better since I quit Facebook a couple of years ago. But it's been, it's been out there for a long time that his core body temperature was 80 degrees, and therefore he could not have been outside for very long. So no, I have not seen them, but I think I know what you're talking about. All right, so this does not have a docket number on it, but let me see if I can. Does anybody know what docket number this is? Because it would help to know if it's been granted or denied. All right, here we go. We'll read it. We'll see. We'll get there. So I don't really even know when this was filed. Let's see what it's dated. March 30th. Okay, so it's only been a couple of days. You would think this would be something she'd rule on right away. Okay. Commonwealth versus Karen Reed. This is intervener, alleged witness Aidan Kearney's motion to be exempted from the sequestration order. Now comes Mr. Aidan Kearney by and through his attorneys and respectfully request that this honorable court exempt him from the court's sequestration of witnesses order. In support of his motion, Aidan Kearney states the following. Mr. Kearney has been named as a prosecution witness in the above entitled action. As detailed below, the Commonwealth has represented that it may call him as a rebuttal witness to establish Karen's purported consciousness of guilt. 2, Mr. Kearney is an independent credentialed journalist who has been issued a press pass through the media office of the Supreme Judicial Court. Journalism is his full-time job and his primary source of income. Since early 2023, Mr. Kearney's reporting has almost exclusively focused on the Reed case. His coverage of the Reed case includes publishing articles which to date number over 500. He's done more work on this than the police. Way more. Live tweeting important case developments as they occur, and hosting an online stream in which he discusses and analyzes issues related to the Reed case. His streams often attract tens of thousands of viewers who watch Mr. Kearney for case news, update, and analysis. The Karen Reed case is a high-profile criminal case which for more than 2 years has been the subject of extensive local and national media attention. The case is a matter of great public concern, in substantial part due to Mr. Kearney's reporting on the matter, which started in 2023, and his belief that Ms. Reed has been framed as part of a corrupt and or incompetent investigation by law enforcement, which has included the Norfolk County District Attorney's Office, the Massachusetts State Police, and collusion with assorted civilian witnesses. Mr. Kearney's reporting played a prominent role in the creation of the Free Karen Reed movement, a nationwide and worldwide group of Reed supporters that has grown so large and is so vocal in their support of Ms. Reed's innocence that the court, balancing the First Amendment rights of Ms. Reed's supporters to express their opinion, the case with Ms. Reed's right to a full trial, created a buffer zone for their free expression prior to the first trial. Due to the immense public interest in this trial, I just lost my spot, which has substantially increased since the first trial, and the court's concern that jurors not be impacted by Free Karen Reed supporters expressing their First Amendment rights, the court has expanded the buffer zone for the second trial. Put simply, the public interest in this case is immense, and it is critical that the credentialed journalist be provided the opportunity to cover and report on the trial. 1 second. In what appears to be the latest move as part of their ongoing plan to silence Mr. Kearney, by suppressing his critical coverage of this case, the Commonwealth seeks to exploit the sequestration order by naming him as a potential prosecution witness, which would subject him to the routine general sequestration order entered in the case, lead to his exclusion from the courtroom, and prevent him from reporting on the case. In essence, the mere act of naming Mr. Kearney as a potential prosecution witness would enable the Commonwealth to silence a journalist who is an influential supporter of Karen Reed and a leading critic and foe of the prosecution. The Commonwealth's desire to entirely gag and sequester Mr. Kearney, such that he could not even observe the proceedings or discuss them in any manner, will harm the public's right to information on an important matter of public concern, since many people rely on his reporting for updates on the case. And because many people don't trust mainstream media to get their news from anymore, as a place from which to get their news. If Mr. Kearney were subject to the sequestration order based on the mere possibility that he might be a prosecution rebuttal witness on the relatively minor issue discussed below, which may not even be admissible against Ms. Reed. It will literally prevent Mr. Kearney from performing his chosen profession, cause him great economic harm, and unduly restrain his First Amendment right to provide the public with information on a matter of great public concern. There is danger that excluding Mr. Kearney from the courtroom and denying him the opportunity to cover this case will be cited as precedent by unscrupulous prosecutors who, in future cases, place any vocal critic with a public platform on their witness list in order to silence their criticism of the government. To the extent the court has any concerns with the impact or content of Mr. Kearney's First Amendment right to report on this case during trial, the court's repeated admonition to jurors about their obligations to avoid any media coverage in this case, including online media, will assuage any concern that Mr. Kearney's right to report on the trial may improperly influence the jury. Indeed, whether Mr. Kearney is able to report on this case or not should not impact the court's well-founded concern that the jury not be exposed to any outside media influence, irrespective of whether that content tends to favor Ms. Reed or the Commonwealth. In considering the Commonwealth's motive for placing Mr. Kearney on their witness list, thereby subjecting him to the sequestration order, the court should take note that this is not the first time that the Commonwealth lead counsel, Brennan, appears to have exploited a witness list by including journalists critical to his position on it for the purpose of suppressing their ability to report on the case, rather than for a good faith reason to examine the journalist/purported witness. In U.S. versus James Bulger, oh, well, this is interesting. They're going to cite the Bulger case against Hank Brennan. Hold on, I need my red pen. The defense team, which included Mr. Brennan, sought to exclude 3 journalists whose reporting was understandably critical of Whitey Bulger, a notorious and treacherous gangster and murderer, by naming them as potential witnesses against Bulger. And here's the decision from 2013. Transcript filed as an exhibit. The court denied the defense's efforts to exclude the reporters from the trial, finding little danger of fabrication, inaccuracy, or collusion. The court noted that the First Amendment interests of the journalists to report on a high-profile matter of great public concern outweighed the minuscule risk that if called as an impeachment witness, their presence covering the case as journalists could shade their testimony. The court also questioned the defense's claim that testimony from any of the journalists would be admissible or necessary. Wow, this is rich. This is well done, Mr. Bradle and Mr. Bellerow. Brennan tried this when he was defending Whitey Bulger, putting some journalists on the witness list. And the court there said, yeah, no, you can't keep him out of the courtroom. Because the First Amendment rights of the journalists are more important than the minuscule risk that you may call them at trial. Here, the ostensible purpose for the Commonwealth's inclusion of Mr. Kearney on their witness list is to keep him on ice as a possible rebuttal witness regarding Ms. Reed's purported consciousness of guilt based upon her alleged communications with Mr. Kearney. Notably, the Commonwealth already has represented to the court that they do not intend to introduce any such evidence in their case in chief, and that they only intend to do so on the rebuttal case if the defense opens the door during cross-examination of witnesses the Commonwealth alleges were intimidated by Mr. Kearney and Ms. Reed. At best, the purported evidence of Ms. Reed's consciousness of guilt and Mr. Kearney's testimony in support of such a claim is weak, speculative, and to the extent that it is even remotely admissible, its probative value almost certainly will be outweighed by its prejudicial impact. Thus, without regard to the merits of the Commonwealth's speculation about Mr. Kearney's knowledge or ability to provide relevant evidence of Ms. Reed's purported consciousness of guilt, the likelihood of the admissibility of the evidence and or the Commonwealth's need for Mr. Kearney's testimony at trial is virtually non-existent and is substantially outweighed by Mr. Kearney's First Amendment rights to report on the case and his right to earn a living. Yeah. And remember also, I don't know if he's going to bring this up because this is a cold read for me. Remember also during the first trial, Gretchen Voss, even though she was on the witness list, was exempt. She was allowed to sit in on the case and she was never called. Assuming arguendo that evidence of Ms. Reed's consciousness of guilt based upon her interactions with Mr. Kearney is admissible, it is hard to fathom why the Commonwealth would deliberately draw attention to Mr. Kearney's actions and his motivation for them by calling him as a witness without having any opportunity to speak to him in advance of his testimony. Right. You're really going to call people that you've never spoken to? Remember they said that to the defense team about the ARCA witnesses. The judge said, really, you're going to call them and you've never had a chance to talk to them? Same thing holds true here, except they had a report from the ARCA witnesses, so they knew what they were going to testify to. Here, they've never been able to interview Aidan Kearney, and they would never call him in a million years. Assuming arguendo that evidence of Ms. Reed's consciousness of guilt is admissible, it's hard to fathom why the Commonwealth would deliberately draw attention to Mr. Kearney's actions and his motivation for them, right, by calling him as a witness without having any opportunity to speak to him. It strains credulity. Oh, there it is. I've got merch. It strains credulity. I love that. That experienced prosecutors would willingly afford Mr. Kearney the opportunity on direct examination, no less, to explain and then place in context the substance of his purported communication with Ms. Reed, where such evidence clearly would be harmful to the Commonwealth's case and almost certainly supports the defense's position. Put simply, the likelihood that the Commonwealth will actually call Mr. Kearney as a witness appears virtually non-existent. And, they're right. You really think the Commonwealth would call him so he could actually talk about how he believes something happened inside the house? Yeah, Curious Liz, can you imagine how epic it would be if Aidan was able to testify? We'd all like to see it. That would be must-see TV as well. It's a game. They just put him on the list to keep him out of the courtroom. I don't think it's going to work, but we'll see. It is clear that Mr. Kearney's First Amendment rights as a journalist to continue his reporting on a matter of great public concern and his right to earn a living substantially outweigh the Commonwealth's dubious and transparent speculative assertion that he may be needed as a rebuttal witness. Mr. Kearney respectfully brings this matter to the court's attention before jury selection begins on Tuesday, April 1st, 2025. And he's been in the courtroom for jury selection, so I'm assuming she hasn't ruled on this yet. And then they cite some case law. In these circumstances, enforcing a general sequestration order to exclude Mr. Kearney, a credentialed journalist, from attending the trial and reporting on this case would violate the First Amendment. There's no question that he has a First Amendment right to attend the trial of this case. To the extent the Commonwealth, and then they cite a U.S. Supreme Court case from 1982, Globe Newspaper Company versus Superior Court. To the extent the Commonwealth has, in fact, sought to exclude Mr. Kearney because he's a well-known vocal and prominent critic of their case against Ms. Reed, the First Amendment does not permit or tolerate discrimination between members of the press in granting access to trials and other governmental proceedings, including where, as here, Mr. Kearney's exclusion appears to be based upon disdain for the content of his reporting rather than his actual need to be a witness. Footnote 1, which is partially redacted. During the first trial, Detective Lieutenant Brian Tully of the Massachusetts State Police, an essential witness against Ms. Reed and Mr. Kearney, acting as a messenger for prosecution witness Gretchen Voss, and then there's a whole redacted, what looks like 3 sentences. Ms. Voss did, in fact, attend the first trial despite being on the Commonwealth's witness list. Well, I don't know what it says underneath those redactions, but the killer bees. Hi, Cal. Cal's here. She's an amazing moderator and an amazing human. Killer bees are at it again. Gotta love it. Yeah, the it strains credulity emoji is Alice in Wonderland because she's on the merch as well. Because call me Alice, I fall into all of these rabbit holes. There it is. I'll put it in the chat. C. Anderson v. Cryovac, 1986 case from the First Circuit that says a court may not selectively exclude news media from access to information otherwise made available for public inspection. Such a practice is unquestionably at odds with the First Amendment. Neither the court nor any branch of the government can be allowed to affect the content or tenor of the news by choreographing which organizations have access to relevant information. And citing a whole bunch of other cases too. Given the unlikelihood that Mr. Kearney will be called to testify, and in view of the exceedingly narrow scope of any irrelevant testimony he might offer, the public interest in his being able to cover this proceeding far outweighs any conceivable interest in excluding him from the trial of this case. Indeed, the Commonwealth sought and obtained exemptions for District Attorney Marcy, and a victim advocate, Steve Nelson, in the case at the case at the final pretrial conference, two witnesses who clearly favor the prosecution in this matter, right? So she said they can sit in on the trial even though they're on the witness list. Finally, based upon their placement of Mr. Kearney on their witness list and recent filings and proceedings held before this court and Judge Sisitsky, it is obvious that the Commonwealth, A, believes that Mr. Kearney's testimony will incriminate both himself and Ms. Reed, and B, knows that if Mr. Kearney is called as a witness, he will be unable to report on this case. Footnote 2. The irony of the Commonwealth's conduct is not lost upon us. In essence, the Commonwealth has placed Mr. Kearney on the witness list for the purpose of silencing his criticism of them with full knowledge it will cause him economic and or emotional harm, which is a form of harassment akin to the witness intimidation charges they have repeatedly charged him with. See? It's like pot, meet kettle. As the court is aware, Mr. Kearney presently is under indictment for several counts of alleged witness intimidation related to his interactions with some of the witnesses against Ms. Reed. In March 2024, a grand jury declined to indict Mr. Kearney and Ms. Reed for conspiring to commit witness intimidation, but on March 20th of 2025, Special ADA Cosgrove represented that this matter was still under investigation and could result in the Commonwealth impaneling a second grand jury. I don't know if he said that in good faith. Oh, look, Jerry Garcia's ghost is here. Responding to someone else. That would make primetime TV. Well done. Putting aside the issue of whether the Commonwealth may offer Ms. Reed's alleged uncharged bad acts, which are presently under investigation, as evidence of her consciousness of guilt during this trial, as a matter to be addressed by Ms. Reed's legal team, if appropriate, it is clear that if Mr. Kearney were examined under oath as a prosecution witness, the Commonwealth would seek testimony from him, which they deem incriminating to Ms. Reed and himself, as related to his existing indictments and the alleged investigations cited by Mr. Cosgrove. There can be little doubt that the Commonwealth would then seek to use Mr. Kearney. There can be little doubt that the Commonwealth would then seek to use Mr. Kearney's Reed trial testimony against him in proceedings against him. Right. In these circumstances, as attorneys for Mr. Kearney, we have no choice but to inform the court that if Mr. Kearney were to be called as a witness against Ms. Reed due to the proposed subject matter of his testimony and the circumstances described above, on advice of counsel, Mr. Kearney will assert his Fifth Amendment privilege and refuse to answer any questions. That's fantastic. It's fantastic. Cosgrove, you're an idiot. You're an idiot, Cosgrove, because if you tried to scare him by saying that the investigation against Kearney and Reed for conspiracy to commit witness intimidation is ongoing, even though the grand jury in March of 2024 failed to indict that ham sandwich, and you said in open court that another grand jury may be impaneled against them, you have now given Aidan Kearney another reason to plead the fifth. And so therefore, even though he's on the witness list, his attorneys are saying, we're not going to let him testify anyway. So you really, really shouldn't keep him out of the courtroom. Right? This fact, without more, should exempt Mr. Kearney being subject to the court's order for sequestration of witnesses. For the foregoing reasons, the court should allow Mr. Kearney to be exempted from the sequestration order. Wherefore, Mr. Kearney respectfully requests that the court enter the foregoing orders and any such relief as it deems meet and proper. March 30th, 2025. XOXO. Timothy Bradle. Mock Betterow. The Killabees. We call them the Killabees. That's what we call them. The Killabees. I don't know what docket number this is, so let me go back to the docket for a minute, see if I can find out. Trooper Paul's pirouette says, with him on the witness list, the Commonwealth can also find out what potential jurors are familiar with him. Right. That's such a great point. Although the question was, do you know or have you had dealings with any of these people? But yeah, how many are going to say, yes, I know who Turtleboy is? And then they're going to try and get him off the jury. Right? That is so great. Thank you, Trooper Paul's premonition. Pirouette. It is a premonition. But you're also Trooper Paul's pirouette. Thank you so much. Let's go back to the chat. Oh, look, YouTube user became a new member. Welcome. Texas Tan Girl became a member. Welcome. Krista Ray. Do you follow Aidan's case? Check out his tweet. Was there a ruling on that today? On this thing? Hold on. I do follow his case. We just read it. We just read the motion. That was from the 31st that he said it wasn't docketed yet. Are you talking about? Hold on. Oh, that was 34 minutes ago. Aidan posted, Lindsay Gattani, the Commonwealth star witness who lied about an assault to have me put in jail and who I am still charged with intimidating based on that debunked lie, has been formally charged in Attleboro District Court with threatening to kill a woman and her children. Her arraignment is April 30th in Attleboro. Wow. That's interesting. I don't know who that woman is, and I don't want to open the floodgates in chat because I don't have enough information on it. So thank you, Krista Ray. And Darlene also became a new member. Welcome. Crunchy Cat, Fun Cat, thank you for your 5. Chrissy, I thought ARCA could testify and was to remedy discovery. Thanks. Yeah, but then they renewed their motion to keep him out because they didn't get the stuff that they wanted, I think. I'm getting so confused. There's so many motions. Okay, I don't know if Aquaphor is not cruelty-free. I'm just trying to fix my chap lips, you know. Sorry if my Aquaphor offends you. I see this. Wait a second. See, you are not a cupcake. You cannot make everyone happy. Chap lips are a very terrible thing. I'll try and find a cruelty-free chapstick. I don't know. And so the answer, Chrissy, is I'm not sure. So many motions have been filed. So many motions have been asked to be reconsidered. Where the hell are we now? She said she was going to have them come in for voir dire next week. And the defense team was like, what? And then they said, the defense team, you can voir dire them the day before their testimony. So it's not really clear. Here's the thing. They can't comply with Rule 14. Rule 14 requires them to turn over everything the experts reviewed in preparation in order to do their analysis in their report. Because the defense team did not hire ARCA to do the initial accident reconstruction, they can't turn over the materials they were given because those materials were given to them by the U.S. Attorney's Office, and they didn't give them to them. And so they can't comply with that. It should not be a reason to exclude their testimony. But again, upside down, inside out world of Narnia. And so the answer is, Chrissy, you may be right. I may be crazy, but that's how I remember it. Thanks for your 10. Grace Base Crosby was fired for failure to supervise when one of his officers did animal cruelty, and he's accredited by a group he founded and is on the board of. Okay, thank you very much. Ms. Bouquet, thank you for your super sticker. Tracy Fagan, if those text messages were obtained before the taint team, how can they be used in Karen Reed's case? Those text messages were obtained. You're talking about the ones between Aidan and Yannetti? Aidan and Yannetti do not have an attorney-client privilege, but Brennan in open court during that hearing said they are privileged, and I'm not looking for those. But then Cosgrove turned him over anyway, and that's when Sisitsky called that emergency hearing, and like that. And said, but you told me you weren't looking for them because they're privileged, and now you say you want them, but you're still not entitled to them, and I'm still not going to give it to you. Again, I will gently remind you that if you would like to go watch something somewhere else on another stream, this is not an airport. You are free to go. But I would just ask that it is common YouTube courtesy not to tell everyone and ask them to go with you, because you're directing them from my stream to another stream. Not cool. I can't believe I have to, like, it's like I'm repeating myself every day. I should put that in like the just basic YouTube rules. Should I put it in the basic YouTube rules, Magic 8 Ball? Should I? Yes. Okay. Guess I'll have to do it. So that's the answer to that, Tracy. I hope that answers your question. Kevin Casey, the analysis is impeccable. Oh, thank you. Thank you, Kevin Casey. Cannone is a disappointment. By the way, for lip service, my dad would use Crisco when we didn't have any chapstick, but I go with Carmex. I don't like Carmex. I find it to be too medicinal. But when I was in Boulder for many years, because I went to college and law school there, you know, you had to stick your finger in that little pot, which I didn't like because it would get on my fingernails, number one. Number two, we used to use Crisco to sunbathe all the way back in the day before, you know, we knew about such things as skin cancer. If you know, you know, girls. Crisco with the, you know, the tinfoil thing out in the sun. Thank you so much for your 10. KAC, thanks for becoming a new member. Sherry Mack, thank you. Is there health data on flights of stairs for Jen McCabe? I do not. You don't know that? Olivia would know that. Does it show her going upstairs to wake her sister and Brian Albert? I've only seen heart rate and steps for her. That's a great question, Sherry. I would defer to Olivia on that. Or there are many other people on Twitter that have analyzed all of Jennifer McCabe's moves. I think there's a spreadsheet somewhere too where they're like side by side, John's and Jen's. If anybody can point Sherry M. McKay to somewhere to find that information, thank you. Just tag her. Her name is Sherry, S-H-E-R-I. Just Joey is here. It says the Commonwealth suffers from an iron deficiency. Maybe. Thanks, KAC, for becoming a member. And Scooter54 for becoming a member. The Commonwealth just made Turtleboy a protected witness. Yes, by putting him on the witness list, yes. So if anybody tries to intimidate him, they too could be charged with witness intimidation, but we know how that goes, right? They only selectively persecute people for witness intimidation that they don't like. People who think Karen Reed is not guilty are the people getting prosecuted for witness intimidation, not people who were in 34 Fairview or out that night at the waterfall, or who may have been witnesses to something nefarious that may have happened. Those people do not get prosecuted for intimidating other witnesses. So it's crazy. Suze, this is the woman, Mary, that Lindsay threatened a while back, and she got an HBO against her. Mary got an HBO against Lindsay. These are criminal charges related to that matter. My memory's exhausted. It's not refreshing my recollection, but it may refresh the recollection of some people in the chat that do watch Aidan. Amanda, for the Aquaphor Fund, thanks for the 5. Best Law Tube show out there for Karen Reed. XOXO2 Michigan. Amanda, XOXO2 Michigan. Thank you. Stormy Storm's Life towards the Chapstick Fund. Yeah, I know. They're like $5 at least each now. Thank you so much. People have a choice to not be here if it bugs you what Melanie does. Thank you. I don't know. There are certain law tubers in particular who are very down the middle of the road, right? They don't pick a side. Everything is like they try and be fair to both sides. And I appreciate that because I can't do that. I can't do that. I can't sit on a fence because the only thing that's going to happen is going to give me splinters and it's going to be very uncomfortable. And I don't like to be uncomfortable. So I have opinions and I'm here to share them with you. And you don't always have to agree with me. You can disagree with me respectfully. But if you're a jerk and you're bullying people in the chat, you're going to get kicked out. I mean, that's just the way it is. People need to understand that the First Amendment does not apply to a private YouTube channel. It just doesn't. So you can't come in here and trash people and defame people and bully people. That's not cool. Most of the people who were neutral in the beginning of the Karen Reed case have flipped over to the Karen Reed, John O'Keefe was not hit by a car side. Okay. Some of them, I don't know. There's one called the Prosecutor's Podcast. I don't know who those people are, but people have sent me some, or they think that Karen Reed should be stoned and stoned in town square. And then it strains credulity. So you're not always going to agree with me and you may not like me, and that's okay. I'm cool with that. I'm old enough to not care. But I'm going to give you my opinions and I'm not going to lie to you and pretend like, this is okay. Cause it's not okay. It's not okay. What they're doing to Karen Reed is not okay. But Bobby Scissorhands is here. I can't wait to see him slice up every single expert of the Commonwealth. Bradford, thank you for your super chat. Since ARCA was hired by the feds and the feds turned over all information to both sides, how is there a Rule 14 issue? Well, the TUI dump, as we like to call it, and I did a whole show on that pre-trial. Josh Levy, who was the acting U.S. attorney for the District of Massachusetts at the time that this TUI dump came out, which refreshed my recollection, I want to say maybe it was like February or something of 2024. Josh Levy had a conversation with both sides. Adam Lally, who was the prosecutor at the time, and the defense team, and said, in good conscience, I cannot allow this case to go to trial, meaning the Karen Reed case. Therefore, I'm releasing all of this information to you. Here it is, 3,074 pages. It may not have included the documents and things that they gave ARCA to do their analysis. It did give them ARCA's report and a lot of text messages and things like group text messages between Matt McCabe, Jennifer McCabe, Brian Albert, Nicole Albert. Tell him the guy never went in the house. That text message thread, among others. It did give them Life 360 data of Allie McCabe. It did give them other things that are escaping me right now. The text messages of Proctor and his buddies. It did give them all of that stuff. So that's the answer to your question. They may not have the stuff that they gave ARCA to do their evaluation, but ARCA does delineate all of those things in their report. Here's what we looked at. You say prosecution has everything defense has, make it make sense. That's the answer to that question. Although ARCA can be questioned on cross. What did you review in coming to your conclusions? And they're going to say, we built a cannon. It was awesome. We built a cannon and we shot a cocktail glass at a taillight, and you can't do it that way. Right. Both sides had equal opportunity to use the ARCA report. Commonwealth could have called them. They didn't. Hopefully that answers your question. Kansas Sofa Juror became a member. Welcome, welcome, welcome. Okay. Goldie says, I'm confused on bias. This was a good question, so I saved it for later. I'm confused on bias and opinion. I feel it's the same. Like my opinion would also be my bias. I would say to you that a bias is a much stronger opinion. Like if you have an inherent bias to something, like if you firmly believe that the defendant is here, therefore they must be guilty, that's bias. Another example of bias is like Vinnie Politan came on my channel recently And he admitted, he said, I have a very strong bias against drunk driving because when I was a kid, I think he said when he was a kid, the family of an entire family in my neighborhood was killed by a drunk driver. And so I have a very strong bias against drunk drivers. An opinion is something that maybe somebody could convince you to sway, right? And a bias often can't be swayed. And that is the difference between the two. And that is an excellent, excellent question. Somebody wants to know if I saw motion number, I can't find it now because the chat is moving really quickly. (661), I think. Hold on. Bias often can't be changed, and opinion can sometimes be changed. Can usually be changed. 661 is defendant's April 2nd motion requesting the clerk's list of jurors. Defendant's April 3rd motion requesting the clerk's list of jurors. Let me see. Let me see if it's in my inbox. Oh, no, moment. Talk amongst yourselves for a second. Talk amongst yourselves. Coffee talk. What's her name? Linda Richmond from Saturday Night Live. It's coffee talk. Talk amongst yourselves. I'm verklempt. I'm verklempt. Thank you, Michelle. Who says, I know someone who knows Lucky. Lucky said the Alberts threatened him before trial. Hope defense can bring that up. Well, that's interesting. And certainly I think they should be able to, unless it was colon, because they can't, I don't think they can talk about colon. I don't think the Commonwealth is going to call colon this time. Dio. Here it is. Here it is. Hold on. Hold on. This is fantastic. Thank you too. Who sent this to me? Hold on. You're going to love it. I think you're going to love it. Thank you to Double Trouble 247 who sent this to me because we were talking about the child catcher from Chitty Chitty Bang Bang. I want to know how many of you still have nightmares about this guy. Anyone? Does anyone out there still have nightmares about this guy? Children. I'm sorry if I just triggered any of you. PTSD. The PTSD is real. Children. Oops. Oops, I didn't mean to do that. There he is. The paddy wagon was fun. Remember, it had candy on the outside and the inside was like a prison and it had bars on it. And he kidnapped the 2 children in Chitty Chitty Bang Bang. It's the worst. Yeah, Brit Chick says, oh yeah, it's the reason I wouldn't rewatch it for years. I remember we had to wait for it to come around. It would only come around to the theaters like once a year. I want to say it was usually around Christmas time. I think Colin was on the witness list, but I can't recall. Is the neighbor a witness for the defense with photos? What neighbor? I think the Asian house neighbor is on the witness list. Al dente. Does anybody know what al dente is talking about? I don't know which neighbor. Does a neighbor have photos? I'm confused. Yes, lollipops, lollipops. Get you all free today. Your lollipops. Amy Chung is the neighbor. Got it. Such a good movie. I loved that movie so much. I would wait for it to come around whenever it was. Came around. Okay. All right. Thank you, Suzanne. Thank you, Suzanne, for getting on it for me and sending me 661 and 662. All right, I'm not going to pull it up, but I'll just tell you what it is. So 662, defendant's April 3rd motion requesting the clerk's list of jurors. Now comes the defendant, Karen Reed, in the above captioned matter to request the updated clerk's list of jurors for Norfolk County. Ms. Reed asked for this list to be released to her lawyers, a jury consultant, and 2 law clerks who are working with Ms. Reed's legal team. Who's the jury consultant? They have a jury consultant? And then, that is docket number 662, dated today. And I'm sure they're going to start like looking them up on social media and stuff. And then there's one from 661 is from yesterday. Now comes the defendant in the above captioned matter to request the updated clerk's list of jurors for Norfolk County. Ms. Reed asked for this list to be released to her lawyers, a jury consultant, and a law clerk who is working with Ms. Reed's law team, with Ms. Reed's legal team. I don't know. I don't think Victoria's the consultant because she's an attorney on the case. She's filed an appearance as an attorney that works in David Yanetti's office. So I don't think that's who it is, because it says she would be included in her lawyers, right? Why did you want me to look at that? Was there any specific reason, or just you were wondering what it was? Anyone? Bueller? Anyone? Now, as far as this, got it. Okay. This is Runkle's tweet that you guys were talking about. So JC, she whose name will not be mentioned on this channel, tweeted, I don't know when this was, maybe yesterday. Judge Cannone will not allow an FBI agent to testify regarding his opinions about mistakes made by the Canton Police Department and the Massachusetts State Police. It was a bad plan to ask a retired FBI agent to provide such expertise. The FBI standards and practices are not, oh, and this is a screenshot, so it cuts off. And then Runkle tweets back to her, so retired FBI agents are not qualified to have an opinion on this. Gotcha, with a little winky face, which is interesting because I don't know how he got to, does she follow him? And that's how he got to respond? Because all of her tweets are protected. And that was sent to me by Alessi Never Sleeps. Thank you very much. That's hilarious. Love it. And I'll allow it. Trisha, thank you for your Venmo. I appreciate you more than you know. No question with that. Okay. People are emailing me asking me to forward emails to other YouTubers. It's hilarious. Susan, thank you so much for your Venmo. No question attached. I appreciate you. If Lucky was threatened, I hope he went to. I hope he presses witness intimidation charges if that's true. That's insane. Okay. This Canton police audit is like 206 pages long. So are there any specific pages that you can point me to that you would like to review, or should we do another stream on it? Laura says, lollipops, get your lollipops all free today. Tracy says, this would be over if Kathy was their neighbor with her curtain twitching. Yeah, Kathy from Gossip, Rumor, and Innuendo. Well, I stole that from her, and I gave her full faith and credit for it. The curtain twitchers, or the nosy neighbors who are always peeking out the curtains, like Jennifer McCabe and Matt McCabe, because they testified that they kept looking out the windows. They saw Karen's car pull up several times and then inch up a little more, and then inch up a little more, and then drive away. So if they saw her drive away, why didn't they see the accident or see his body on? None of it makes sense. They're all strange credulity. But yes, Kathy has a channel called Gossip, Rumor, and Innuendo. She releases videos every morning. She's hilarious. I get my laughs of the day from Kathy. Do you too? I love her, Tracy. Thank you. Chloe Albert's Revenge. Bias is a lens you view things through and guides actions and decisions. Bev's bias makes her rule in favor of the Commonwealth, even if her decisions contradict each other. Opinion. Karen smiles too much for a defendant. Yeah. She smiles too much. She opens her eyes too wide. Her skirts are too short. Her bags are too expensive. Her shoes are too expensive. She eats at steakhouses. Yeah, all of it. Great point. Thank you. And thanks, Kelly Applegate, for becoming a new member. Appreciate you all. Let's see. It's been 4 hours and 15 minutes. I kind of feel like we should save the Canton report for another stream because there's so much to it. But you could let me know what you think. You could let me know what you think. I'll watch the chat for another minute. See if you guys have any further comments, questions, concerns. We all love Kathy. Kindergarten cop says, Melanie, it's a puff piece. Only parts worth anything are crime scene investigations, interviews of witnesses, handling of evidence. Oh, so it's pretty short. Sue says it's very long. Yeah, I mean, they did find that the use of a leaf blower was innovative. Yeah. Don't leave us now. Where did I get my hat? Pretty sure this came from like one of the Mexico runs that like Dedham Company did. Pretty sure. Because, you know, Cancun, that's why you got to get your I went to Cancun with Melanie little merch. That says free Karen Read on the front. Yeah, listening fatigue. It's a lot. It's a lot. So let's do that. Here's what I'm going to do. I'm going to timestamp this video so that you can fast forward to your favorite parts. I usually do that and pin the comment, or I put it in the video description. The part regarding social media influencers and followers made me real. Oh, now you've piqued my interest, Carol. You've piqued my interest. I'll go back and watch it. Another stream. Okay. Do you guys want to do a cupcake invasion on someone? Hold on. Cruelty-free chapstick. Here. Information is knowledge. Knowledge is power. Power is corrupt. Wine is strong and emperor powerful, but truth conquers all. Yes. And absolute power corrupts absolutely. Thank you for allowing me to add to your quote. I love you with all of my heart. Want to see you soon. I'm going to die. Most talkative is here. What's the difference how the attorneys question Colin and Allie since the Commonwealth is not calling them? Thank you and love your show. Oh, if the defense calls them on their case in chief, they have to use direct examination. They can't use leading questions. So it has to be a little bit more friendly until if and when you are able to declare the witnesses hostile, in which case you'd have to ask the judge, Cannone, to give you permission to treat the witness as hostile, which would give you the ability to use leading questions and things like, isn't it true that you really didn't leave 34 Fairview at 12:10? Isn't it true that you called Aaron Beatty at 12:33 from 34 Fairview to drive you home? Isn't it true? You know, like that kind of stuff. That's leading, and it's more confrontational. But if you call them on your case in chief, it has to be like, you know, matter of fact, the way you question a witness on direct. Veronica truly became a new member. Thank you so much. Thank you so very much. All right. Do we need to do a cupcake invasion somewhere? Let me see if there's anybody out there. Oh, the giveaway. We forgot the giveaway, Mother Rucker. Thank you. Thank you. Thank you so much. Okay, hold on a second. I have to, every time I do it, I have to Google how to do it because I forget how to do it. It's a StreamYard thing. All right. It's a special page I got to open. Okay. Choose a live stream. This one. All right. Here's what you got to put in the chat. If you want to be in the giveaway, you can have your choice of merch. But you have to be willing to email me your address today. My email is in the show notes. Wait, don't put it in yet because I didn't set it up yet. I know MN Vic Queen, you're very into it and you're already there. If you put it in more than once, you will be disqualified. Hashtag FKR in the chat if you want to be involved in the giveaway. You have to be willing to give me your address today. My email is in the show notes, fanbase@mlittlelaw.com, and you can have your choice of shirt or mug, whatever you want. And then we spin the wheel And it's fun. It's just a fun thing for us to do. And it's fun to give stuff away because I'm a giver. And then we get to watch it, and then it like spins the wheel. It tells us how many people have entered. And so we'll let that run for a second while we cover a few more questions. Mad Hatter 214, thanks for your 5. Formerly AJ's full-throated motion. That was such a good one. You're Mad Hatter 214, I'll allow that too. Just got my merch, black hoodie, cannot wait. Oh, that's awesome. And look, David Reese, changing the name again, bloviating Breenan. The only thing that got me about the audit was that they actually said that a search warrant infringes on Fourth Amendment rights. Yeah. Who are these people? As Jerry Seinfeld used to say, who are these people? Who are these people that were hired to do this audit? Is it a company that just does that? Do they do it nationwide? Are they Massachusetts based? I have so many questions. Those of you who are local to the area of Norfolk County probably know who this company is. I don't know who they are. And I kind of want to digest it anyway, instead of just pulling out pieces of it for you. But yeah, they don't care about the Constitution in Massachusetts. We know that. We call it Massachusetts. No, I mean, the Goodmans sent me their address, but they didn't win yet. Only if you win, send me your address. Don't send me your address if you don't win. I'm not trying to get your addresses. You guys are hilarious. No, wait. Only if you win, send me your address. You guys are helping me build my my snail mail list. Cruelty-free chapstick. Oh, we went over this one. Thank you again. But that was an excellent thing. Okay. We're going to do more than one. We're going to do more than one. They're not local. All right. Stop for a moment. Oh, it doesn't matter. Keep putting it in. Hashtag FKR. There's only 416 entries right now, and there's over 7,000 people here. Is it US only? I think that they ship. I know they ship to Canada. I know that. And the shipping's on me anyway, so if they don't, because there's a problem with FKR. The audit was done in November of 2024. I mean, they didn't exactly have chain of custody to audit. Yeah, that's true too. And the Goodmans are like, now you can come for dinner. All right, I might take you up on that. Never write a check you can't cash. And never extend an insincere offer. All right, we're at 475. I'm going to spin the wheel. You ready? Hold on, I'll make it bigger so y'all can see it. It's a very exciting time. It's a very exciting time here at Cupcake Nation. Ready? Go. Let's see who's going to win. Who's it going to be? 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 Let's see who's the winner chicken dinner. The winner is Masshole Madness. Woo! You are the winner. You are the winner. Please take a look at the merch shop. The link is pinned in the chat. You will go there. You will pick out what it is that you like. Tell me the size and the color. Send me your address. We'll get that done for you. Masshole Madness. Winner number 1. Winner. How many should we do? Well, you know what? 3 is a good number. Do you remember that? 3 is the perfect number. Is that like an after school special thing? 3 is the perfect number. Winner number 1, Masshole Madness. Coming in hot. And everybody needs one. I don't know. Everyone, but don't put it in again if you already put it in once, because it will disqualify you. It doesn't matter if it's all caps or what it is. 5 Stones is the name of the company. Maybe they should be stoned 5 times. I don't know. I really don't know what it says. I think some of it was good and some of it was not so good. Vi Craven, in the pursuit of justice. Thank you, Mel, for keeping us all sane and encouraged. You are like a 10 plus stars shrink in a massive group therapy session. I feel like it's too. I feel like it is group therapy. It should be group therapy. We need it. There's no shame in having a therapist. Everyone should have one, because now you can do it on Zoom. Oh, what do? You got to put hashtag FKR in the chat, and then you will be entered in the Attorney Melanie little merch giveaway that we're doing right now. You just have to be willing to email me your address if you win. Yay, Masshole Madness. Woo! All right. We're going to draw again. The odds are pretty good because I think there's only like 591 right now. Okay, ready? Here we go. Who's it going to be? Who's it going to be? Who's it going to be? Emma says I sent 2 emails, but would only take a few minutes to review. Labeled second email today and lovely Alan Jackson video. Thanks for doing these lives. Oh, thank you. Swiss Miss is the winner chicken dinner. Swiss Miss. Congratulations, Swiss Miss. Come on down. Come on down. Emma. Not Emma. Swiss Miss, come on down. Emma says she sent me 2 emails of videos of Alan Jackson. Okay. Oh, and this is clips from Dave Portnoy and I don't know, some of his guests. Yeah, I don't want to play that because they might strike me. And Dave Portnoy, I don't really know. And also there's an F word in Nurse Kim's tweet. But you guys can go you can go to Nurse Kim's Twitter. I know. I'm never going to call it X. Never. All right. Winner number 1 was Masshole Madness. Winner number 2, Swiss Miss. Now, we're going to, in 1 minute, go to winner number 3. But first, we are going to set up a cupcake invasion. Do, 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 do. There's nobody live right now that I can redirect to. Oh, well. Okay. Back to the show. Let's see. Let's see what happens here. Thank you, Emma. Bewildered in Texas. Thank you. Neutrogena lip balm. I lived in Boulder 40 years. Saw the Dead at Folsom Field 3 times. Oh, I love it. I love it. Love Boulder. Love the Dead. Love it all. I've seen the Dead since Jerry died, but I never saw them with Jerry at Folsom Field. Thank you so much for the memories. Cruelty-free chapstick. Hi to you all from Aberdeenshire, Scotland. Been tuning in since Rittenhouse because loving your wit and wisdom and law tubers, brothers and sisters, free Karen Reed. I didn't cover Rittenhouse, but a lot of my law tube brothers and sisters did. That was way before my time in this area. But you've been tuning into LawTube since Rittenhouse. Yeah, that was that one got a lot of play. Thank you so much. Isabel, did you see my super chat as I left for a while? Yes, and I put it up on the screen. So sorry if you didn't see it, but I delete them as I go. Otherwise, I don't remember where I am. So thank you. I'll thank you again for your super chat. Okay, here we go. Ready? This is number 3. Number 3. Here we go. 716 have entered this time out of 7,000. And here we go. Here it is. Do, 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 do. Who's the winner going to be? Who's the winner going to be? Who's the winner going to? Sushi! Sushi is the winner. Sushi. Yay, Sushi. Come on down. Congratulations. Congratulations. To all winners. Those of you who have won today's prizes, make sure you go to the link that is pinned in the chat where the merch is. Pick out what you want. Tell me the color, the size, and put in the subject of your email like sushi winner, giveaway winner, and then give me your address and send it to my email, which is linked in the show notes below. Fanbase@mlittlelaw.com. Fanbase@mlittlelaw.com. Thank you all for playing today. Have a wonderful rest of your day. Emily Baker does not allow redirects. I can't redirect to her. So if you want to go there and tell her I sent you, you can do that. But she doesn't allow, like the creator has to allow people to redirect to their stream. And for some reason, she doesn't. Even though I subscribe to her, it's not coming up. So go on over. Thank you guys. Thank you to the moderators for keeping it classy today because it has been over, it's 4.5 hours and without them, we would not be able to do this. Meaning I would not be able to do this. So thank you, moderators. I love you. With all of my heart. If I don't see you soon, I'm going to die. Do everything that YouTube likes, please. It helps a girl out, helps the algorithm, helps the word get out there about Karen Reed being framed. Right here. I even have a mug for that. Microdots has these mugs. Hit the like, hit the subscribe, hit the bell because you never know when I'm going to go live and you don't want to miss it. And if you don't have all notifications set and notifications set on your phone, you're not going to know. You're going to miss it. You're going to be bummed out. You're not going to be able to participate. Congratulations to today's winners. Masshole Madness, Swiss Miss, and Sushi. Reminder that there is a 20% off coupon in the merch shop. You just need to make sure you click on it at the top of the thing. The mascara on my Amazon list that doesn't clump is Benefit. It's made by Benefit. It's Benefit Roller Lash. It's the best. Stay cool, Stig. The glare is live, but he doesn't allow redirects. I don't know why. I've told him to fix it. He says he doesn't know how. So wherever you go, tell them from where you come. Emily Baker, the glarer, and that's it. Stay cool, stay kind, stay classy. I love you all with all of my heart. If I don't see you soon, I'm going to die, but I'm probably going to see you soon. At least by tomorrow. So there's that. Peace, everyone.